Order. Welcome, everyone. My name is Barbara Adams, and I would like to call Law Amendments Committee to order and to welcome everyone to One Government Place. I will be the chair for most of today's meetings. I'm going to now ask all of the members of the committee to identify themselves for the record, starting with the government members.
Good afternoon, John A. McDonald, MLA for Hants East.
Good day, Marco McLeod, MLA Pictou West.
Yeah, good afternoon, Pat Dunn, member for Pictou Center.
And good afternoon, my name is Steve Craig. I'm the member for Sackville-Cobequid.
Hi everyone, I'm Lisa Lachance. I'm the MLA for Halifax, Citadel, Sable Island.
Gary Burrell, Halifax, Shabukto.
Good afternoon, everyone, and welcome. Rafa Di Costanzo, MLA for Clayton Park West.
Hi, everybody. I'm Braden Clark, MLA for Bedford South.
Thank you, everyone. I'd also like to recognize Legislative Counsel with me today, Gordon Hebb, Killian Schlemmer, and Karen Kinley. Is she here in the room? She's not here today. All right, so these are just some of the housekeeping rules for today. So I'd like to request that everybody please turn off their cell phones or put them on vibrate. I would also ask that anybody attending in the audience always be respectful. There is to be no shouting or cheering for or against what is being discussed today or any other disorderly behavior. If there is disorderly behavior, you will be asked to leave. The taking of pictures or video by anyone other than the accredited media is not permitted. Presenters are not to use any kind of props. Copies of all written submissions on a bill that have been received by email up to the time when the bill is reported back to the House or in person during the law amendments meeting will be given to library staff to be posted online. Submission received after a bill has been reported back to the House are distributed electronically to Law Amendment Committee members but are not posted online. The agenda for today, listing the order in which presenters will be invited to speak, is available for viewing on the small table to the left of the door as you enter the room, I believe. For scheduling purposes, all presenters today were required to provide prior notification to the Legislative Office that they would be speaking on the bill, so we will proceed from that provided list. You will notice we're going back and forth from one bill to another to accommodate presenters who are coming in at different times of the day. When your name is called, please come forward and state your name, how you would like the committee to address you. In my case, I would say Ms. Adams, and the organization, if any, that you represent. Once again, in order to allow all of the scheduled speakers an opportunity to speak at a reasonable time, we will be keeping track of time. You will each be given a set time to make your presentation remarks, followed by receiving and answering questions from the members of the committee for up to 5 minutes. I will alert you when there is 1 minute left to your speaking time, and when time is up, we will move on to the next speaker. Regarding to presentation times, just for the record, if there are 8 or less presenters on a particular bill, each speaker has up to 15 minutes total. Typically, that's usually around 10 minutes to present, and then approximately 5 minutes for questioning from committee members, if they have any, for a maximum of time of 15 minutes. Note 1 question at a time per member, and there is no follow-up. Once all of those who wish to ask a question have had a chance, if time permits, I will allow a second question. Once we conclude the 8th speaker of a particular bill, then the presenters, number 9 forward, will have 5 minutes to present and 5 minutes for questions for a total of 10 minutes. If presenters have handouts for committee members, please provide them to the pages for distribution. And I will remind everyone, presenters and members, that you need to be recognized by the chair before you speak so that your mic is on and that your comments are captured for the record. Does anyone have any questions before we proceed? Okay, thank you. And I'm just going to get my clock ready to go. All right, so we have one bill, Bill number 459, the Health Professions Association Continuation Act, that has no presenters. So, yes?
Oh, sorry.
Sorry, John A. McDonald?
I might have jumped the gun, but I expect you need a motion from me to get it reported back.
Could I have a motion from the floor to move the bill back to the House without amendment? Okay, a motion has been made.
You have to say MLA McDonald.
I'm new to this, folks. Hold on. I recognize John A. McDonald.
I move that bill number 459, Health Professional Associations Continuation Act, be reported back to the House without amendments.
Thank you. Moved by John A. McDonald. All of those in favor say aye. Aye. Opposed? Motion carried. All right. So we're going to start now with our first presenter. So this is bill number 455, the Emergency Management, an act to establish a department and authorize the establishment of a Nova Scotia Guard. So the first presenter is Joe Triff. Thank you very much. So I now recognize Joe Triff. Can you please introduce yourself and how you'd like to be referred to?
Sure. My name is Joe Triff. I'm the Vice President of the Halifax Professional Firefighters. I'm also the Nova Scotia Vice President for the Atlantic Provinces Professional Firefighters, representing all IFF firefighters in Nova Scotia. If you'd indulge me, we had a second speaker who's unable to attend today. I'd like to ask if Mike Sears, another member of our Halifax Professional Firefighters, could join me in lieu of Brendan Marr not being able to attend today.
Are we allowed substitute? Are we allowed That would be fine.
Would you like Mike to introduce himself?
Yes, please.
Michael Sears, I'm the Government Affairs Liaison for Halifax Professional Firefighters, Local 268.
Okay. All right. Thank you very much. Please start your presentation.
So I apologize, I don't have a formal presentation. We were only made aware of the meeting today on Friday, and so we scrambled over the weekend. But we've come to speak to you about Bill 455, and to express a little bit of frustration. We're asking the government to pause this bill and engage labor. This is the third time that the sitting government has introduced legislation without consultation of the professional firefighters in this province. It was first done around the cancer presumption, then it was done around the Financial Measures Act, and now we see Bill 455. I represent the professional firefighters in Yarmouth, Halifax, Truro, and Cape Breton Regional Municipality, and we have not had an opportunity to consult on this bill. We have concerns that exceed our time limits today on speaking. We have concerns about existing services. And we feel that government needs to better understand what we currently have in Nova Scotia and how those current existing agencies can be better supported, i.e. fire, ground search and rescue, Red Cross, Salvation Army, agencies that are already providing services that this Nova Scotia Guard is being touted as a replacement for. In our experience, municipalities with paid services will reduce anything that's being duplicated by the province. So, for example, we had both of us operated in Pictou County after the hurricane. We were part of the Urban Search and Rescue team based in Halifax. It's one of 6 federal teams that are disaster response teams. We spent almost 2 weeks in a tent on a cot in a sports field in Pictou County, helping get power restored, clear trees off of power lines. If the province is looking to set up a group of individuals with chainsaws, our employer is very likely to stop providing training and chainsaws because the province will step in to do that. We have concerns that those services need to continue at the municipal level. We did see some positives with the addition of a Minister of Emergency Management. You may have been aware in the media recently our concerns as a professional organization about the fire school in this province and safety concerns. And we see a new Minister of Emergency Management as an opportunity to look at fire services in this province as a whole, and how can the province better support fire agencies, firefighters in this province with proper professional training facility managed by the province that is safe and effective for all the firefighters in Nova Scotia. The frequently asked questions document that was circulated that I received this morning from another agency does not reference professional firefighters in any capacity. It does reference the Tantallon wildfire, with both of us operated it for an extended period in 2023. It references that wildfire as the catalyst for this Nova Scotia Guard, and yet the people that were doing the bulk of the work on that disaster were not consulted. We're simply here today to ask for an opportunity to have our voices heard before this is sent back to the House. And I'll defer to Mike for...
Okay. I recognize Michael Sears.
Thank you. I can't help but echo the exact points. It's simple. We were left out of the conversation. We've been very open to all members of government and all parties that we're willing to work with anybody on any issue that affects professional firefighters. We also stand with our partnership with Greg Jones and FSANS. We work very well together. Simply, we're here today because we found out about something at the last minute that appears that it's being pushed through. We're not in opposition completely to what is happening. We just want to help shape it so that it's done properly and right, and that it ends up landing exactly where I believe the intention is, to support Nova Scotians. So I ask, consideration, defer the timeline on this. Please stop rushing it through if that's what it appears that is being done. Offer consultation. We're here to work with you. We want to be supported. We want to make sure that this gets done properly. I'm going to yield the rest of my time to allow for questions.
Thank you very much. So we'll start and go down the order. So I'll recognize Braden Clark.
Thank you, Madam Chair. And I just wanted to, I was refreshing my memory on this, but this bill was introduced in March, actually, March 28th of this year, at the tail end of our spring session, just first reading, which is quite unusual. My memory might be a bit hazy on this, but I recall the sense around the legislature at that time was that the government had introduced it and not debated it to give time through the spring, summer, and now approaching fall to consult. And obviously, at least in the case of professional firefighters, that didn't happen. So that's concerning, to say the least, bizarre. So I will just put those facts out there because that's what happened at the time. And this is a question for either Mr. Triff or Mr. Sears. What would you say when you look at this piece of legislation? What would you say is beyond the fact that obviously you weren't consulted? What would you say is the biggest gap or the biggest problem you see that could result from the bill the way it's written today?
I'm just waiting to see who wants to speak. Okay, thanks. I recognize Michael Sears.
Through the chair, thank you for the question. I think in this case, the bill appears to be quite broad in its nature and its scope, which in a lot of ways can be beneficial, but in a lot of ways it can go against the intention of a particular piece of legislation. That's what we want to see not happen. We also don't want to see contraction of municipalities to offer less services that become overwhelmed instantly, expecting the province to step in and pick up the slack.
Thank you. I recognize Rafa Di Costanzo.
Thank you, Madam Chair. My question is, are you concerned that a lot of your volunteers may be hired or taken over by somebody, the new Guard committee that's been established? Is that one of your concerns, that you're short on volunteers, let alone having somebody else take them for you? Is that one of the issues?
I recognize Joe Triff.
So just to be very clear, we represent the career, full-time professional firefighters in the province. Having said that, we work very closely both within HRM and beyond with volunteer fire agencies. And the trend across the province is that it is hard to recruit and retain volunteers. I believe the average for a new HRM volunteer is around 3 years retention, and that includes almost a year of training. So yeah, we don't want to see people. It's already hard enough to find folks to volunteer in any capacity. The cost of living around here has really diminished people's time that they can spend volunteering because they've got to seek additional income to make ends meet. We don't want to see something introduced that makes it more stressful on the agencies that are already providing the services, the shelter, the food. We see the portable Salvation Army truck that arrives on scene and feeds people. We see the Red Cross doing good work on evacuations. We don't want to see a new agency stood up that draws from that pool of individuals.
Thank you.
Thank you. Does anyone else have questions? I recognize Lisa Lachance.
Thanks. So, I mean, obviously deeply concerned about the lack of consultation, and I really appreciate your willingness to come here today and share that, and also be willing and a partner in this if invited in. So I'm wondering a couple of things. So how do you currently, do you have a regular way of consulting with the government or with EMO? And do you have a regular meeting with volunteer firefighters? Like, between last March and now, were you invited to any meetings with government? And at the same time, between last March and now, did you meet with volunteer firefighters in the province?
Thank you. I recognize Joe Triff.
So as a representative of the career firefighters in this province, I and the folks I represent were not invited to any meetings that I'm aware of with government regarding this bill. Not to say that our employers may not have been invited, but the representatives of the folks that do this work, full-time firefighting as a career, were not invited to the table.
Thank you very much. I recognize John A. McDonald.
Thank you, Madam Chair. And I represent East Hants, which has 13 volunteer firefighters and departments. I shouldn't say firefighters because there's 13 departments. And I know there was a couple of sessions there I was able to attend. One of them, it was, I'm going to say, pretty well attended when it's there. So I'm just confused a bit because I know there's been like 18 different sessions out, and I know 14 other events, and there's been meetings with NGOs. Is your concern that your one organization wasn't directly asked? I mean, I went to the event because I knew it was there, so I went to it. I didn't get a formal request to attend. I sat in the back as any member of the community could.
So I recognize Joe Triff.
So yeah, we weren't invited, and that is the Yarmouth professional firefighters, the Truro professional firefighters, the Cape Breton Regional Municipality professional firefighters, and the Halifax professional firefighters. The Atlantic Province's professional firefighters. There was no communication with our organization to A, let us know that these meetings were taking place, or B, invite us to attend or participate.
Thank you very much. I now recognize Gary Burrell.
Thanks. So we're just trying to think more specifically about the pause that you're asking for. What kind
Carry
of time?
on.
Sorry?
Sorry.
Yeah.
Carry on, Gary.
Yeah. What kind of a time frame we might envision that taking? What the components it might have. In other words, if it's probably not something that would delay the measure going forward for a great time. I just wonder if you could speak about a little more detail about what the pause might involve.
Okay. I recognize Michael Sears. Go ahead.
Simply, through the chair, it's an opportunity for consultation.
Yeah.
To sit with those key components, people that are at the table, that are making the decisions, to understand the intention, to offer feedback so that if something is intended to be one way, when you look at it through different sets of lenses, you often see it in a different way. So what we've been able to see quite often is a willingness to work with us when we're in front of people. So if we can get our point across and we can offer our suggestions and our experience over decades of doing this work, especially in this province alone, not necessarily just in one component of the province, I don't see it taking an exceptionally long amount of time, but it's just allowing that time to be had.
Thank you. I recognize Pat Dunn.
Thank you, Madam Chair. I'm just a little confused because I thought the invite was out there in the websites and in the media for anyone to attend. I attended one as a spectator in Petro County, and there was a number of fire departments attending that from the county that particular evening. There was 18 sessions with volunteer fire departments with ground search and rescue teams. There's 30 sessions with organizations like Red Cross, Salvation Army, United Way, more than 20 in-person and virtual community engagements with all kinds of different community groups, leaders and groups and so on throughout this span of time. So I feel like it was an open invitation to anyone that wanted to attend any of these in-person sessions or sessions virtually that occurred during the last number of months, Madam Chair.
Thank you. So I recognize Michael Sears. Oh, sorry, Joe Triff.
Thank you. Yeah, respectfully, I've been an elected representative of my members for 12 years. I've been in front of committees here more than once. We dealt extensively with the government, actually with all three parties, on presumptive cancer legislation, our lobby efforts to get the coverage increased for firefighters in this province. We dealt with the government on the Financial Measures Act. We're not new to representing firefighters with this government, but we were not invited, and we were not aware that there were public meetings. I can't speak to why we weren't aware or why we weren't consulted, but that at the end of the day, our voices were not heard during this consultation period.
Thank you. I just remind everyone there's 1 minute left. Lisa Lachance.
And so what would you see the value of a specific consultation with professional fighters being?
I recognize Joe Triff.
I think we would like to see the Nova Scotia Guard as something that we can support and encourage our members to participate in. And in its current form, we don't believe that's the case. We want to make sure that this Nova Scotia Guard isn't infringing on our collective agreement or our collectively bargained workers' rights. We want to make sure that this isn't something that is going to impact current municipal services. And we believe that the way that it is being rolled out may be detrimental to current resources at the municipal level.
Thank you. I recognize Steve Craig for 30 seconds.
Thank you, Madam Chair, and I just want to pass on this information. Good to see you again. Just want to pass on this information. I noticed in social media this morning that there is a community meeting on the Nova Scotia Guard this evening, 6 or 6:30 and to 8 at the Joe Zatzman facility over in Dartmouth, so the former Dartmouth Sportsplex. Just for your information. I'm sure your members have seen some of that too. So.
Thank you very much, and thank you to the two presenters. We'll move on to the next presenter, which is Brendan Mayer. Oh, he's Mar. Oh, he's not come. Sorry. My apologies. Thank you. So now we are going to switch over to Bill number 464, the Stronger Workplaces for Nova Scotia Act, for a number of speakers. So our first presenter is Duncan Robertson. So Duncan, please introduce yourself to the group and ask or share with us how you would like to be acknowledged.
Yes, my name's Duncan Robertson. You can refer to me as Duncan, Mr. Robertson, whichever you'd like.
Thank you. Please go ahead with your presentation.
Perfect, thank you. Well, Chair Adams and members of the committee, thank you for allowing me to join you today to speak on Bill 464. My name is Duncan Robertson. I'm a senior policy analyst at the Canadian Federation of Independent Business, and I'm based here in Halifax, Nova Scotia. As you may know, we are Canada's largest non-for-profit organization devoted solely to the needs of small businesses. We represent 97,000 members across Canada, 4,000 of which are right here in Nova Scotia. Today, my comments will be focused on the section of Bill 464 that proposes amendments to the Workers' Compensation Act. It's clear to employers and employees alike, Nova Scotia's workers' compensation system badly needs reform. And that is why it's heartening to see the Minister and her staff bring forward amendments to the Workers' Compensation Act to take prompt action on some key areas identified by the 2024 Workers' Compensation Review. CFIB supports much of this bill, such as the introduction of a purpose to the Workers' Compensation Act, enshrining reviews of the WCB system every 5 years into law, and ensuring both employees and employers are active in the return to work process. As is highlighted in the Workers' Compensation Review Report, claim durations are an area that must be addressed. Based on the most recent data, the average WCB claim duration for Nova Scotia was 167 days, while in Manitoba, a province with a comparable population, it was only 35 days on average. This issue has played a large part in the poor financial position of the board and what it finds itself today, and its inability to improve benefits for employees. Small businesses appreciate that government has proposed some new actions through Bill 464 to improve claim duration by holding employers and employees accountable to cooperate in the return to work process. However, we believe that the amendments to the Workers' Compensation Act put forward lack the needed clarity and as a result leave too much to the discretion of the board. This is particularly evident in Clause 21, which sets out the penalty structure for non-cooperation in the return to work process. First, this clause does not define what is considered acceptable contact and what frequency of contact is considered maintaining contact. For example, is one attempted phone call every month, a single voicemail, or an unopened chain of emails considered acceptable? We believe that this must be legislated and not left to board's discretion to ensure clarity both for both parties as well as any workers' compensation case manager as well. Second, the penalties imposed to the employer compared to those to the employee are unbalanced in both the severity and method in which the penalties are imposed. Under the proposed amendments, an employer would be charged the lump sum of the total amount of any compensation payable to the injured worker of the employer during the period of noncompliance, and any other expenditure made by the board would also be paid by the employer as well. In contrast, employees can be charged on a scale ranging from a suspension of benefits, still receiving the benefits but at a reduced rate, withholding benefits, or termination of workers' compensation benefits. And we believe that if the action of an employee, in the opinion of the board, is seen as failing or refusing to comply with the return to work requirements, the employee should be charged a penalty that is comparable in severity to what is imposed to the employer. Now, we're not saying cost, but severity in terms of that deterrent to noncompliance. It is important to note that small businesses stand to lose the most from an employee not actively participating in the return to work process, and why there must be a clear disincentive to non-cooperation. The majority of members we represent are comprised of 10 or fewer employees. A prolonged absence of any employee can result in noticeable lost revenue for these businesses via missed business opportunities such as the inability to fill orders or meet demand. In fact, the current labor shortage, which over 7 in 10 small businesses in Nova Scotia face, costs small businesses in the province collectively $1 billion in 2023. We must not add to the burden facing small businesses, and we must ensure that the WCB system is not exacerbating this issue. So while tiered penalties for employees may seem reasonable when considering the relationship between an employee and an industrial employer, we ask that you consider the disproportionate impact noncompliance has on small businesses and the need to have clear, well-defined, and meaningful disincentives to non-cooperation in the return to work process. In summary, we're asking for committee members to consider the following amendments. First, legislated definitions of the following: acceptable communication, as well as maintaining communication, to again ensure clarity both for all parties involved and any case manager as well. We would further like to see Clause 21 amended to ensure the severity of the disincentive to non-complying with the return to work process is comparable between employers and employees. And again, that's not in cost, but in severity. Finally, we would ask that you add the following subsection to Clause 21. When the action of an employee are deemed by the board as failing or refusing to comply with subsection 2, that if an employer has between 1 and 99 employees, the board will reimburse the employer for the cost of wages that would have been paid to the employee over the course of the period of non-compliance. to assist in the coverage of lost productivity. So what we're looking for is some kind of financial support to these small businesses if an employee is not complying. Of course, the employee themselves will be getting penalized, but there's still that possible lost revenue and lost productivity that would come from that employee not being involved in business. Of course, for a small business, that is far greater of an impact than a business of 500 employees, for example. So we hope that our members' views and these recommendations will provide your committee with the necessary insights as you consider amendments suggested by the public. And with that, I'm happy to take any questions you may have.
Thank you very much, Duncan. Okay, I'll recognize Braden Clark.
Thank you, Madam Chair. Mr. Robertson, good to see you. Just a quick question. You mentioned claim duration in 167 in Nova Scotia versus 35 in Manitoba. Could you just define kind of how is that from the date an employee makes a claim to when it gets approved, for example? Is that what I'm referring to, what you're referring to?
Recognize Duncan.
So my understanding,
Robertson?
my understanding is that is when the claim is submitted until the claim is finalized, until the person gets back to work. That's my understanding of that case, of course. And again, a lot of the length is because, again, the return to work process isn't as efficient as it could be. And of course, making that more efficient would benefit employers, particularly small employers, as well as employees as well.
Thank you. Does anybody else have any questions? No? Do you have any closing remarks you'd like to make?
Just again, sorry.
Oh, sorry, I recognize Duncan Robertson.
Just to consider, of course, the realities facing small businesses are far different than those facing industrial employers and larger businesses. So when we are seeing, again, labor shortages impacting many small businesses, even having one other employee, not back at work actively is definitely a concern. And as the review report suggests, it's important for employees to be at work. They're better at work. They're able to recover faster when they're able to be, again, at work, be either in their current form or at a different role as well. I'm just making sure, again, that we're making the return to work process as effective as possible is very important.
Great. Thank you very much.
Thank you.
Thank you. The next I will call Heather Mulligan. Thank you. Heather, can I ask you to introduce yourselves to the committee and how you would like to be acknowledged?
Yeah, my name is Heather Mulligan. I'm the Manager of Advocacy for Atlantic Canada with the Canadian Cancer Society. And I'd also like to ask if my colleague and my friend, Kathy McNaughton, can join me as well.
Yes, she can. Thank you.
Kathy's joining us from Westville, so she's made quite the drive to be here today.
Thank you. Kathy, would you like to introduce yourself?
Oh, okay. First time. My name is Kathy McNaughton, and I am the lead advocate on the bill that was passed for David's cause, where EI benefits went from 15 weeks to 26 weeks. Wonderful. And you can address me as Kathy.
Thank you very much. I'll let you start your presentation.
Wonderful. Thank you, everyone. Chair, and good afternoon, members, and for giving us this opportunity. As I mentioned, my name is Heather Mulligan, Manager of Advocacy for Atlantic Canada with the Canadian Cancer Society, and Kathy and I are here to speak in support of Bill 464, the Stronger Workplaces Act, specifically those measures within the Act that looks to extend job protection from the current 3 days to 27 weeks. It's a critical change, one that we both believe that will make a difference in the lives of Nova Scotians. No one ever plans on hearing the words, "you have cancer," but for 2 in 5, it will be a reality in their lifetime. And for nearly 40% of them, it will come at a time in their careers when they are focusing on building or thinking about retirement. It will come at a time when they are also looking at buying their first home, paying down debts, or simply providing for their families. At these times, people are juggling multiple responsibilities and priorities, of course, facing a cancer diagnosis, you have people who are coming to depend on you as well. We also know that these are already difficult times. The cost of living crisis and affordability dominate conversations, whether it be at the cash register when you're getting groceries, at the pharmacy, or, of course, in the legislature. Meanwhile, we know that the costs of cancer have consistently been increasing in addition to this. As elected officials, you're hearing from Nova Scotians every single day around the struggle to make ends meet while managing a cancer diagnosis. For some, it's about having enough funds to fill your gas tank to travel into Halifax in order to afford the gas to get that test, that diagnostic, to get that diagnosis to determine your treatment journey. For others, it's that heartbreaking realization that a drug that was approved and prescribed by their oncologist is not on the provincial or their private formulary and simply is stuck in a drug approval process. And also for far, far too many, it's managing the responsibilities of life, having your kids in hockey or soccer practice, birthdays, putting food on the table, all while living on a reduced or no income at all. But there's hope. Thanks to advancements in treatment, more and more people are surviving cancer and returning to work than ever before. And these individuals want and deserve a chance to rebuild their lives. Part of that is knowing that they have a job to return to. That's why the Canadian Cancer Society has partnered with Department of Labor, Skills and Immigration and the official opposition to push for these vital changes. And together, we've advanced a conversation around unpaid leave, advocating on behalf of our patients and our families. And as Kathy mentioned, in the fall of 2022, the federal government responded to these advocacy efforts, including those of the Canadian Cancer Society, by extending the EI sickness benefit from 15 weeks to 26 weeks. This is the first major change to the benefit since the 1970s. And Kathy and Dave have a lot to do with that, and I look forward to allowing Kathy an opportunity to share their story. But the work is not finished yet. In provinces like ours and Nova Scotia, there is job-protected leave, where their job-protected leave is shorter than the federal sickness benefit. Workers can access EI, but they do so at the risk of losing their jobs. Bill 464 is directly addressing this gap by extending job protection leave to 27 weeks, and it also allows it to be taken over a 52-week period, recognizing that, as treatment evolves and changes, as should the ability to take leave and be integrated into your workplace during a journey. So when passed, Nova Scotia will be setting a new standard, one that we're hoping that other provinces are going to follow. Currently, Quebec is the only province aligned with the federal EI sickness benefit, offering 26 weeks of job-protected leave. However, we're seeing momentum across Canada. Manitoba, Ontario, Prince Edward Island, New Brunswick, and Newfoundland and Labrador have all launched or they've completed consultations on this ask. And Nova Scotia, by passing 464, is going to lead that growing movement towards a more compassionate and forward-thinking approach to workplace protection. So on behalf of the Canadian Cancer Society, we wholeheartedly support and endorse 464. It's more than just a smart policy, it's the right thing to do. Cancer doesn't wait, but your job should. So I'm going to pass it to Kathy.
Thank you. I'll now recognize Kathy McNaughton.
Hi, thank you very much for the opportunity to tell you about the story of David's and I's journey with when he was diagnosed with cancer. He was diagnosed in December 3rd, 2013 with esophagus cancer on his 50th birthday. We went to EI to apply for sick benefits. Then we started our plan for him for his recovery. So he had to have 25 bouts of radiation, 3 intensive bouts of chemotherapy, come home, get his strength back up. We're going to have an operation to take out the diseased esophagus, recover, and go back to work. Well, that plan didn't work. First of all, in March, we got a letter saying that his EI was being cut off because sickness benefit was only 15 weeks, even though he had 30 more weeks of EI. Within the next 2 weeks, he got a diagnosis from his surgeon that the cancer had spread, so it went to his liver and his aorta, so it was deemed terminal. Now, David should have focused on his life that was left, but all he worried about was, where was the money going to come from? How am I going to pay bills? We were surviving on the EI benefits, but when it was cut, we went to $852 a month. David even took a job when he was sick and installed a floor so he could get the money to pay for the insurance on the car, on the truck. Sadly, David passed away on August 4th, 2014. Cancer killed David, but the Canadian government broke him. And I thought, this is so wrong. So I started David's Cause on 2014 in September. Thank you. And I advocated for 8 years. I partnered with Tim Houston, Sean Fraser, and then finally the Canadian Cancer Society. And we were a great partner. We ran with it, and as Heather said, EI bill was passed, that EI went from 15 weeks to 26 weeks. So we celebrated. Yes, I did it. And then, then Kelly from Canada Society said, we're not done. They got their 26 weeks, but they don't have job security. All they have is 3 days. And I thought, oh my God, this is so wrong. I said, what do you want me to do? So then we partnered with MP Kellen Reagan, and she presented the bill to have the labor laws, the job security from 3 days to match the 26 weeks. That was in April of 2023. Well, I'm proud to say that within the year, we have it tabled on it that Nova Scotia will be leading the advocacy to have the labor law change to 27 weeks. I am so proud to be in Nova Scotia, and I'm so, we identified a problem and we fixed it, and it didn't take 8 years. So thank you very much, and I approve.
And I know we're not supposed to show any applause, but I'm sorry. Thank you. So we just have 5 minutes now for questions. Rafa Di Costanzo, of course, we'll start with you.
Thank you. And it's heartwarming. It is. It brought tears to my eyes, but a woman alone who could advocate, that is what is so special about what you did. And we thank you. Thank you from the bottom of the heart, especially for someone who just went through cancer herself. It puts you in a whirlwind. And the last thing that we need to worry is about money or a job. I was lucky, actually, I looked forward to working because that took away a lot from, I didn't have physical work, so mental work I was able to do most of it, but I know what your husband went through, and it isn't easy, it's hell. So I thank you. This is huge for many people, and you did it on your own with the help, and I thank Kelly and our party who brought in the bill, and thank them, and thank the new PC party for taking it over and passing it as part of this bill. So everybody worked on this, and thanks to you and everybody else who helped you. So from the bottom of my heart, I think the world of you. Thank you.
Thank you, Rafa, and I'll recognize Lisa Lachance next.
Thank you, and thank you so much for being here today. So I'm really pleased to hear that we'll align with the federal government. Is there anything missing from this bill? What else could be added to it to enhance people's job and financial security when they have cancer?
Thank you. So I recognize Heather Mulligan.
Thank you so much. This is actually a good question for the Department of Health and Wellness, and specifically looking at a lot of the support programs and services that we offer our patients, and ensuring that they are not only in alignment with inflation, but they are constantly looked at and reviewed. We do have some support programs and services, many of which we ourselves offer between the Lodge That Gives, that provides free overnight accommodations for rural Nova Scotians, our travel treatment fund, which tries to help fill the gas tank. Therefore, the most vulnerable in our communities. Many of our programs and services have a low income threshold, and unfortunately, the Canadians that we're speaking about, the Nova Scotians, they're the ones who have families. They're middle income, and so a lot of the programs and support packages that we have for our patients simply doesn't meet the need for families who are just trying to get by right now with the cost of living. So there is much more. We partner with the Department of Health and Wellness. We have these conversations, and so I know Minister Thompson and her team are very well aware of our asks as it relates to affordability, but there's certainly much more that we can be doing, especially when it comes to drug access, take-home cancer drugs, and supportive therapies, and ensuring that we have a system that is nimble, that is responding to the needs of our patients, but also doesn't have cancer drugs out of reach. When you consider the cost of a 21-day supplies is $7,500 for most people, so we can certainly do more.
Thank you very much. With just 2 minutes left, I'll recognize Gary Burrell.
Quickly, I mean, everything you said, of course, all of us, I'm sure, would wish to congratulate you and to agree. But I wanted to ask additionally, in Cancer Society's advocacy along these lines, is there any discussion about advocacy for paid leave? And does the question of paid leave come on the screen for the Society?
I'll recognize Heather Mulligan.
There are conversations across Canada as it relates to this ask. So, for example, if we look at our Atlantic sisters, Prince Edward Island, for example, had a comprehensive review that they conducted in 2022, and then it concluded in 2023. From a top-down, a complete evaluation of their labor standards. That included pay as well as unpaid leave. New Brunswick also similarly did the same last year as well, looking at paid and unpaid leave, and we're still waiting on the outcomes of that. And we're hoping that, when the government is a newly elected government comes in, that job-protected leave is one of the priorities. So yes, there are conversations across Canada that are happening. For us, in terms of our patient population, we need to focus on unpaid leave. We know that many Canadians have access to appropriate supports and services through their employers, but there's a quarter of Canadians in particular that are not covered and are falling through the cracks. And so we need to make sure that safety net is there to catch them and make sure that it is responsive to their needs.
Great. There's just 30 seconds left, so I'll use that time to thank you both so much for being here today. We really appreciate you being here, and thank you very much. So our next presenter is Danny Cavanaugh. I'll ask Danny to come forward. Thank you, Danny. I'll ask you to introduce yourself and to share with the group how you would like to be acknowledged today.
Okay. My name is Danny Cavanaugh. I'm the president of the Nova Scotia Federation of Labour, and we represent 70,000 unionized workers here in the province. And Danny is fine, and I do have copies of our written presentation here, but I'm just going to do a summary of what's contained in this because I don't have enough time to go through the whole document. So,
great. The floor is yours.
Thank you. So as I said, my name is Danny Cavanaugh. I'm the president of the Nova Scotia Federation of Labour. The Federation advocates for better laws to protect all workers, unionized or not. So today I will summarize key points through that are made in our written submission that the committee will receive. The proposed Stronger Workplaces for Nova Scotia Act improves labour standards, but needs further changes to protect worker rights more fully. The Workers' Compensation Board must act, and the whole workers' compensation system must act as a justice system for injured workers. But Nova Scotians, injured workers, have historically received some of the lowest benefits in the country. These amendments offer a chance to correct that, but workers' justice must not be comprised of lower employer costs. WCB must provide a fair compensation and recovery support without prioritizing lower premiums for employers. Injured workers gave up their right to sue, trusting that WCB would ensure justice and fair treatment for injured workers. The return to work process must be based on a genuine medical evidence not employer pressures. Universal coverage is also urgently needed, as around 74% of workers in this province remain uncovered, and that's shameful. Regarding the Labor Standards Code, the bill extends unpaid leave for serious illness and family responsibilities, but increases the sick leave to just 5 days, which falls short of the 9.5 national sick leave average according to Statistics Canada. We recommend at least 10 paid sick days annually to ensure workers can recover from illness without financial stress, and privacy must be protected when requesting information to support any leaves. In the Occupational Health and Safety Act, we support the inclusion of mental health in the definition of health, but urge for specific mention of bullying and the full integration of the ILO Convention C-190 addressing violence and harassment. The Workers' Compensation Act should involve injured workers in regular reviews and guarantee job security and rehabilitation support for those returning to work. Penalties for non-compliance should only apply to workers who unjustifiably refuse to cooperate, not those with legitimate medical reasons. A written document, as I said, goes into this much further detail, which we hope will be taken seriously, and the government is willing to work with us to make positive changes to WCB so it helps those who it was meant to.
Thank you very much. Open the floor for questions. Emily-Lise Lachance.
Great, thank you. Thank you for being here. I'm wondering, you talked about the need to make sure that return to work is managed through a medical model and is evidence-based. Can you talk a bit about what the effect is or what you've heard from folks who have been pressured to return to work when it's against their physicians or other clinicians' advice?
Recognize Danny Kavanagh.
So there's a lot of injured workers out there who go to their own family doctor who tell them, you're not able to go back to work yet. But at times they get forced back to work, which doesn't benefit anybody. If somebody goes back to work too early, they only reoccur that injury and end up being off for a longer period of time. So it just can't be about the dollars and cents or numbers on a page. I think that people need to take a serious look on a case-by-case basis at each injured worker and work with their own medical doctor about, getting them to return to work as quickly as possible. We don't disagree with that, but it can't be too soon, and it can't be at any cost, especially the cost of the injured worker, and being off and making sure their injury is kind of looked after through their own medical practitioner, right? Not a WCB doctor who at times a lot of people feel are forcing them back to work too quickly. And I think, I don't think there's much disagreement that there's a lot of distrust with the WCB system. And, I've talked to folks at WCB about how we need to change the system to make sure we're building more trust in the system so it actually helps the people that it's supposed to, the injured worker.
Thank you very much. I recognize Gary Burrell.
I wanted to ask about, all of this comes out of the recommendations of the review, and I know that the Federation has followed this all very closely. Might be useful for the committee to hear what some of the Federation's general analysis of the review, where it's strong, what are some of the gaps, and just to speak to the review as a whole.
Recognize Danny Kavanagh.
So, that's a good question. To start with, when the review committee was mandated, we had some issues with the appointees to the committee because some people were appointed as employee reps who were not employee reps. So we had a bit of a back and forth about some of the appointments on the committee, and we were successful to get some change made there. But in terms of the overall document, I don't think it's that bad, but we make a number of points in our document about things that we feel need to be changed. So, you know, things like paid sick days and some other issues. I think that we need to look at the WCB system as a justice system for injured workers, and that's what it was fully intended to be when it started. As it, you know, workers gave their rights up to sue an employer in turn to receive justice for their injuries that they might have received at work. And oftentimes over the years, I would contend that now that we have the lowest rates paid to injured workers and through their compensation, that the system hasn't been working much in their favor. It can't be all about lowering costs. Employers signed off and agreed not to be sued in order to fund the system adequately enough to make sure injured workers get the compensation that they deserve. So I think that would be my main point. It's not, you know, people will contend that it's an insurance system, but it's not. It's a justice system for injured workers, and injured workers need to get the justice that they deserve when they're injured at work.
Thank you very much. I recognize Braden Clark.
Thank you, Madam Chair. Thank you, Danny, for being here. I wanted to ask you, you touched on something in your comments which is important, and I think a lot of people don't fully realize perhaps is how far behind Nova Scotia is compared to the rest of the country when it comes to coverage. You know, most provinces have 98, 99% coverage, generally speaking, and as you say, we're in the 70 range. And as you touched on in your previous answer, benefits are relatively low and rates are relatively high compared to the rest of the country. So those are two kind of competing problems, and it's hard to solve both at the same time. So from your perspective, what would you begin with? Do you think it makes more sense to talk about benefits and rates for existing covered workers and employers? Or do you think priority should be placed on coverage for the 20-odd% of people who have no coverage at this point?
So I'll recognize Danny Kavanaugh.
So I think if we move to universal coverage, which we support, would be one avenue to collect more revenue. If employers think their rates are too high, it's because there's a number of workplace injuries in those workplaces, and employers want to reduce rates. The easiest way for them to reduce their rates is to not have as many accidents in the workplace. So I think the whole culture of workplace health and safety needs to change a bit in this province, but you know, if a workplace has fewer accidents, then their rates will come down automatically, right? So I think that's part of the problem. And you know, if you think about universal coverage and the 74% of workers that aren't covered in this province, and you consider that the agricultural sector, for example, is exempt. I mean, when you think about that and you look at who's lumped into the agricultural sector, and I use this example all the time. So if somebody's working in a golf course is considered in the agricultural sector. So there's a lot of dangerous work that happens in a golf course, specifically if people are mowing grass and those kinds of things. And when they receive an injury, because those happen, you know, I don't know how frequently, but you know, when those things happen, then those workers, I think, a lot of times don't even understand that they're not covered till all of a sudden, you know, they find themselves with an injury only to be thrown to the curb because they don't have any other means of income because they were injured at work. So I think, you know, and there's a lot more. It's a huge subject matter, I think, but universal coverage, other provinces have it, and there's no reason that this province can't move towards universal coverage.
Thank you very much. All right, thank you all very much. Thank you very much, Danny, for coming to present to us today. We're going to take a 5-minute recess to allow Ledge TV to do a little bit of maneuvering. So thank you very much, Danny. Good afternoon, everyone. We're going to resume law amendments. Our next speaker is Rachel Barber. I'll ask Rachel to have her seat and to introduce herself and to share with us how she would like to be acknowledged during these proceedings.
Thank you. My name is Rachel Barber. I am here today representing the Office of the Worker Councillor, which is a program of the Nova Scotia Federation of Labour. You can call me Rachel.
Thank you very much. The floor is yours.
Thank you. So many of you have probably not heard of the Office of the Worker Councillor, but I suspect most of your constituency assistants have. Our organization provides assistance, education, and advocacy to Nova Scotian workers when they are dealing with the workers' compensation and the occupational health and safety systems in this province. Over the last 10 years that I've been in the role, we've supported well over 3,000 individual workers, and we've assisted those workers to address multiple individual issues. Many of those workers came to us in 2015, and we're still working with them today as they're working their way through their claim journey or with their occupational health and safety concerns. Our mandate includes the provision of input and feedback to the Nova Scotia government to contribute to the system's improvement and evolution. And I'd like to thank the committee for the opportunity to be here today to provide that input and feedback into Bill 464, the Stronger Workplaces for Nova Scotia Act. I do know the name. So we've reviewed the draft legislation carefully because obviously it has significant impacts for the clients that we serve. And at the Office of the Worker Councillor, we had some small but essential recommendations for amendments to the legislation as it stands. I'll focus on occupational health and safety legislation and workers' compensation legislation as well, but I did at the end have a brief comment with respect to the labour standards legislation as well. So with respect to occupational health and safety legislation, we are incredibly pleased to see the addition of psychological health and safety to the Occupational Health and Safety Act. It's something that's been long overdue. The recognition of psychological hazards in the workplace is essential, and it's fair. And we need to start addressing the risks that people take every single day to their mental health when they go into the workplace. And I think this government has done a great deal of work to that end, and some of those changes are very encouraging. There's just one little thing that we would like to see changed in the legislation itself. And Section 13.4 of the draft legislation says every employer shall, in accordance with the regulations, establish and implement a policy respecting the prevention of harassment in the workplace. And we feel that it's important that it refer not just to harassment, but to harassment and bullying. And that is because in the compensation world and in the health and safety world and in the legal world in general, harassment and bullying are two very distinct things. Harassment is generally defined as targeting an individual based on a protected ground under the human rights legislation. So, for example, targeting someone for their race, for their gender, for their sexual orientation, or for their age. That is considered in general harassment. Bullying, on the other hand, is usually defined quite differently, where bullying is targeting an individual not because of a protected ground, but because of some other personal characteristic, or occasionally for no reason at all. So we felt as though the legislation should be crystal clear that they're not just referring to harassment, but also to bullying. And certainly our organization will also be involved in any regulatory review or consultation, rather, when that time comes. But we felt as though it was important to have the distinction that both bullying and harassment are covered under the occupational health and safety legislation we felt it was important to have that made very clear, simply because of the different definitions in other arenas. So that's pretty much it on the occupational. Oh, when I say that's it, no, I didn't mean I'm finished. Everyone's, thank goodness. No, that's it for occupational health and safety. I apologize. I'd now like to talk a little bit about the workers' compensation legislation. And again, we had some kind of specific recommendations for the legislation itself. We do really look forward to the opportunity to participate in policy consultation, and that's what we will do when that time comes as well. But the draft legislation itself, we felt needed some changes. We had concerns with Section 1A of the draft legislation and the purpose clause. And that purpose clause talks about the purpose of the Workers' Compensation Act and how it is intended to, in a financially responsible and accountable way, promote health and safety, facilitate rehabilitation, and so on and so on. Certainly, the Office of the Worker Councillor has no objection to any of those goals, as outlined in the draft legislation. However, where we are concerned is the definition of those goals as the purpose of the Act. In our view, the purpose of the Act comes directly from the Meredith Principles of 1913, and I don't know how many of you have heard of those principles. I worked at the Workers' Compensation Board for 15 years, and it was the first thing I learned on day one. The Meredith Principles are the foundation of the workers' compensation system across Canada. And those principles are no-fault compensation, security of benefits, collective liability and employer funding, independent administration, and exclusive jurisdiction. So those come from the Meredith Report in 1913, and though that defines the purpose of the worker. And we're concerned that adding another purpose somehow makes the Meredith Principles secondary. Mr. Kavanaugh said earlier, and I will say it again, the workers' compensation system is not an insurance company. It is not a rehabilitation system. The workers' compensation system is a justice system. Workers have surrendered their right to pursue justice through the courts of law in exchange for this system. And to us, that is fundamental to the legislation. And again, while we have no objection to any of the purposes outlined in Clause A1, what we have seen in the work that we do is a system, and I shouldn't say a system, what we have seen is sometimes a misunderstanding that about the workers' compensation system, about what it is and where it comes from. And we really feel that it is important to focus on the roots of the system as a justice system. So our recommendation at this point would certainly be just to remove that purpose clause and revisit it for a later period of legislative amendment. Failing that, we would like to see some reference to the Meredith Principles in that purpose clause and to the justice nature of the purpose of workers' compensation. Let me see. We'd also like to draw your attention as well to Section 89A of the draft legislation. And again, we're so pleased to see the return to work process enshrined within legislation, particularly the return to work process in the event of a temporary injury or impairment while folks are waiting for recovery. That said, we feel as though it's important to ensure that that piece of legislation includes the caveat that both workers and employers shall cooperate to the extent that is reasonable. And we say that because we have seen circumstances in which workers and employers are put into unreasonable situations. And it's our concern that this legislation is very prescriptive and allows no room for exceptions whatsoever. I will end very quickly by saying that the changes to the Labor Standards Code are very encouraging. The one thing we would like to see, however, is similar language surrounding return to work included.
Excuse me. What I'm going to suggest now is there is 5 minutes remaining for you. It's your choice if you'd like to continue with your presentation or if you'd like to move to questions. You're welcome to continue with your presentation if you'd like.
Thank you, thank you. No, I think we can move to questions. I appreciate that.
All right. Thank you very, very much. Are there any questions? I recognize Gary Burrell.
Well, what is the language that we would want to change in the Labor Standards Code then?
Sorry, I recognize Rachel Barber.
There is no existing language in the Labor Standards Code with respect to a duty to assist someone return to suitable or alternate employment. So currently the proposal is to have an unpaid leave in the event of illness or a serious illness, I think was the term. And it would be our suggestion that the Labor Standards Code include a requirement on employers to offer suitable work in the same way they do when someone's been injured in the workplace.
Thank you very much. Any other questions? I recognize Gary Burrell.
Well, this point about looking at the system from a justice point of view rather than a risk management point of view, it seems to be so core, really, to all of what you said. I wonder if you might just speak to that itself. What is the difference, and the primary difference in these two different ways of looking at compensation?
Thank you. I recognize Rachel Barber.
Thank you for the question. I think in our experience, the primary difference between considering the workers' compensation system to be an insurance company versus considering the workers' compensation system being a justice system, the primary difference is a cultural one. And what our experience has been working directly with many of the amazing employees and staff and leadership at the Workers' Compensation Board, our experience has often been that there doesn't seem to be a recognition that their decisions must be taken very seriously at all times, that their decisions must be based on the weight of evidence, not on what, as a caseworker, you think is good for this individual or is what your policies or internal procedures say about return to work. Your decisions must be based on the evidence. And I think when the workers' compensation system focuses on making decisions based on evidence, they do far better with their outcomes, both with respect to return to work, claim durations, claim costs, and appeal outcomes, because it's the evidence that must dictate the decisions being made under this Act.
Thank you very much. Are there any other questions? No? Thank you so very much for taking the time to be here today. We really do appreciate your feedback. Thank you. So I'm not seeing our next presenter.
There's someone on this side.
I'm just going to ask if someone could check to see if there's someone, our next presenter's waiting in the foyer. Okay. Okay. So is Kevin here? Well, thank you very much. We're going to move on to our next presenter, if you're ready to go. Thank you, Kevin McMullen. I'll ask you to take your seat when you're ready. You have seat there. Thank you. And we'll ask you to introduce yourself and to share with the group how you would like to be acknowledged or in question. Thank you. I recognize Kevin McMullen.
Hi, my name is Kevin McMullen. I'm the business manager, CEO of the International Union of Operating Engineers. We represent all the ground paramedics, the Lifeline team, clinical transport operators in the province of Nova Scotia.
Thank you very much. Please begin your presentation.
Chairperson and committee members, thank you for allowing us an opportunity to address the amendments today, and that to Bill 464. Stronger Workplaces for Nova Scotia Act. First, thank you to the members and the others who participated in these amendments to the Labour Standards Code of Nova Scotia. Our province is rich in heritage, and advocating for workers' rights, as has been demonstrated many times in the past by workers and their unions working together, looking for a better future for their families. Politically, politicians aware of their dependency on votes from their constituents have also worked to alleviate some hardships in the workplace over a period of time. This amendment does contain certain clauses that assist in the plight of workers. However, much more is required in order for ordinary workers without a workplace insurance plan for illness or injury. We address such things as serious illness or serious injury, whereby an employee is entitled to an unpaid leave of absence of up to 27 weeks. This is certainly an improvement, and with the current federal sick unemployment being 26 weeks, would seem adequate. However, as we all know, that could change with an amendment to the Federal Government Unemployment Act and be reduced to, say, the old 15 weeks of coverage, and if you qualify. Reality is that unless a worker has insurance through the employer for sickness or injury, which usually only comes through collective bargaining by a union, they could see significant financial distress. As we all know, with our demands on the healthcare system, receiving prompt medical diagnosis and treatment is not very quick, and a period of 27 weeks can evaporate quickly. And an employee has to wait 6 months before taking any additional leave under Section 60 FA. Section 60G of Chapter 246 is being amended to 5 days of unpaid leave per year due to the employee's sickness or injury, and 3 days of unpaid leave due to sickness or injury of a child, parent, or family member, and also for medical, dental, or similar appointments during work hours. Again, this is an improvement. However, as COVID has taught us, sometimes even 7 days is not enough. And also, this is unpaid sick leave, which affects the family's financial situation. Especially with the high cost of rent, mortgage, and fuel and food costs that are very high, this impacts our citizens who can least afford any loss of income. Perhaps this can be revisited and some sort of compensation can be arranged for these periods of leave to better protect and strengthen family financial outcomes. Health and safety, including both physical and psychological health and safety, is important and a welcome change. And it has been said that after a period of 18 to 24 months absence from the workplace, chances of returning are very low. We should be looking at speeding up the process of treatment, and if not possible, to return to the same occupation, a pathway to alternative employment might be feasible in some cases. We often hear of a toxic workplace, and having every employer, in accordance with the regulations, establish and implement a policy respecting the prevention of harassment in the workplace is a good amendment. However, every good thing such as this requires monitoring and policing in order to be successful in the workplace. Promotion of health and safety in workplaces will require government follow-up and monitoring to be successful. So I urge this committee to establish a system to make sure employers are compliant. Workers, organizations, and employers will have to work in collaboration to support the WCB system for the benefit of workers and employers as we move forward into the future. Safe and timely return to the workforce from injury or disease is essential, and Section 89A 1, 2, and 3 are improvements that should, with education and follow-up, assist in this matter. Employers' cooperation in the early stages of a safe return to work of employees should always consist maintaining communication throughout the employee's recovery. Providing suitable work if available will assist in the employee's financial situation, as well as foster better relations between the employer and the employee. And employees will have to maintain communication with the employer, providing necessary information, as well as working with the employer on a safe and early return to work if possible. The implementation of penalties to an employer who fails or refuses to comply with the Act is also a welcome addition to these changes, so that the employer is aware that cooperation is essential to maintain the WCB system. I hope that these improvements and suggestions to enhance these changes are implemented for the betterment of the system. In solidarity, Kevin McMillan, Business Manager.
Thank you very much. Are there any questions? I recognize Rafa Costanzo.
It's not really a question. I'm just a little bit confused. You went from back and forth between 27 weeks and 26 weeks. I was told it was 26 weeks, but in your presentation, 27 came up twice. So is there a reason why we exchanged the two?
Oh, sorry. I recognize Kevin McMullen.
I'm pretty sure it's 27 weeks in the change here, the amendment. I may be wrong. I've been wrong before.
So I don't have it in front of me. Go ahead. I recognize Rafa Costanzo.
Thank you. It's in your second paragraph, about the fourth line, you said unpaid leave of absence up to 27 weeks. And then in the following sentence, you said current federal sick unemployment. That's right. The federal, they're specifying 26 weeks for EI. And then in the following paragraph, you went for 27 weeks again. So I just wanted to know why one of them is 26 and one is 27. I thought it was unusual.
So I'm going to recognize John A. McDonald.
So the difference would be on the federal EI, which is 26 weeks, and the provincial changes to the bill are to allow 27 weeks of unpaid leave. So two different governments, two different requirements. That's why Mr. McMullen, thank you, quoted them both, because they're two different governments. We're doing 27 unpaid, but EI is up to 26. Thank you, Madam Chair.
Thank you. Are there any other questions? Thank you very much for coming in today. We really appreciate you taking the time to be here.
Thank you very much for having me.
You're welcome. So now we're moving on. Oh, is Hillary Richardson Murphy here? No. Okay. So we are now going back to Bill number 455, the Emergency Management and Act to establish a Department of and authorize the establishment of a Nova Scotia Guard. So our next presenter is Pascal Rodier. Thank you very much for being here. We'll ask you to introduce yourself and to share with the committee how you would like to be acknowledged during questions. So I recognize Pascal Rodier.
Thank you, Madam Chair and members of the committee. My name is Pascal Rodier, R-O-D-I-E-R. I'm not representing any one organization. I am here with I had to think about it, over 35 years of public safety and emergency management experience in 3 provinces. So I'll be speaking on behalf of this bill. And Madam Chair, just a clarification. I was told 10 minutes with 5 minutes of questions, or is it 5? Are we switched back?
You have 10 minutes for your presentation, and then another 5 minutes either for a continuous of your presentation or questions.
I promise, Madam Chair and Committee, I won't take the full 10 minutes. So
Thank you. The floor is yours.
Try and cut you some time. Thank you. I'd like to begin by thanking Premier Houston for introducing this bill, this government, as well as the parties that each of you represent, for this important move to enhancing our province's capabilities in emergency management. This is a tremendous first step on the pathway of improved provincial preparedness. I'd also like to acknowledge the first responders, emergency managers, those in healthcare, volunteers, GSAR, First Nations, NGOs, faith-based organizations, and the citizens that continuously step up to help others in need during disasters and emergencies today. Nova Scotia is no stranger to major incidents, and Nova Scotians always step up. However, we have an opportunity right now to make things better, and based on lessons learned and adapting best practices. What we need is better coordination to support these amazing people, and what is needed is provincial programs and departments to have better alignment internally and improved interoperability externally. I wholeheartedly support Bill 455 and its focus on establishing the new Department of Emergency Management. I also support exploring deeper what this means moving forward. Recommendations such as the Nova Scotia Guard are essential to an organized response to any major emergency or disaster. Having a strong volunteer cadre that we know is vetted, trained, exercised, and equipped ahead of time makes huge impact to the size of any response. All while working alongside those existing volunteer groups and NGOs that already provide such great services to our communities today. Experience has demonstrated repeatedly that emergency management practices are most effective when locally executed, provincially managed, and federally supported. This mission cannot be accomplished alone. It requires mature and strong partnerships at the provincial level, local, and First Nations levels. All levels of government, along with the private and non-for-profit sectors, share responsibility in emergency preparedness. Emergencies and disasters, including low and no-notice incidents, can overwhelm government at all levels and threaten the safety and security of Nova Scotians. They are life-altering incidents for those impacted with the potential of injuries, fatalities, widespread destruction, and economic impacts. These incidents disrupt lives. They hurt our communities both physically and emotionally. Readiness is critical for the province of Nova Scotia to ensure that the response and recovery missions are appropriately executed and are successful. Emergency management and response in Nova Scotia must take a whole-of-community approach. Breaking down the barriers is key to emergency planning and response, but only if those barriers are broken down well in advance. Aligning the key areas of emergency management under one minister, as such bringing together incident management, training and emergency exercising, continuity planning, public safety field communications, 911 information management, planning and preparedness, disaster financial assistance, in addition to implementing the Guard, increased regional field staff, and regional emergency operations centers will enhance the capabilities of these government departments to provide provincial leadership along with regionalized and local support. In addition to the operability improvements of these government departments, this bill sets out language for improved interoperability. The new integrated department working closely with communities, First Nations, and the private sector. Enhancing relationships before the bad thing happens between all levels of government and those responsible for responding helps to improve preparedness for all. One of the challenges that we face is that decision makers and the public often only see the response phase. Much of that is heavily influenced by the media and social media. That's where all the fancy stuff happens, right? That's when the cameras come out and everybody's there doing all the work. What people miss is that emergency management is 4 phases. The prevention and mitigation phase, which is really that period of time where we can do what we can to either diminish or eliminate the hazards that impact us. The preparedness phase, which is really the phase where we bring people together. That's where we set up our planning, That's where we establish our resources. That's where we really bring people to work together, training, exercising, and have processes in place for when things may or may not happen. The response phase, as mentioned, relatively small, but it gets all the time. It gets all the play. And the recovery phase, which we know can take days, weeks, months, and even years. We're still recovering from a number of impacts to this province. But preparedness is really where the response fight is won. If the province fully invests in preparedness, it's investing in the response capabilities. This bill should also support the challenges of limited resources in this province. Few communities in Canada, and Nova Scotia is no different, are fully self-sufficient for all the hazards that they may face. By better planning and coordinating the various supports that are available across the province, the appropriate level and types of resources can be mobilized where and when required. In addition to helping those impacted by the incident, there's fiscal advantages to supporting all hazards preparedness through this new department. According to Public Safety Canada's 2019 Emergency Management Strategy for Canada, for every $1 invested in preparedness and mitigation, $6 can be saved in emergency response and recovery costs. In the U.S., that ratio in 2019 was for every dollar spent and $11 was saved. And we know that those numbers are much higher today based on the cost of everything. While fiscal impact should never trump the human factor in emergency management, the fact is disasters are becoming more and more costly for all levels of government. To be successful, funding and resources need to be at a level consistent with the expectations of government and the public. The funding and resources need to support all 4 phases of emergency management. But the funding also needs to be available for provincial staff to participate, provincial development opportunities, training and education, and gathering best practices from other jurisdictions. I am excited about the monumental move forward. However, I hope that we'll see it go relatively quick and we don't have a lengthy implementation phase. For us to have a truly resilient province, we must have resilient, prepared communities and neighborhoods. All emergencies and disasters begin at the local level and are the responsibility of those communities. Only once the requirements exceed the capabilities of the local supports, does support come from other areas and levels of government. Supporting Bill 455 is the first step on the pathway to provincial preparedness. Building expanded capacity on the excellent foundation that already is set out by Nova Scotia EMO and the others that I named earlier, we are at a pivotal moment to truly making Nova Scotia safer today and for future generations. In conclusion, I'd like to thank again those that helped people before, during, and after disasters. And we know that every emergency and disaster is unique in its own set of challenges. Yet the spirit of constant improvement, we must explore how best to prepare for, respond to, and recover from future threats to Nova Scotia. Thank you, Madam Chair. Welcome any questions.
Thank you very much. Are there any questions? Well,
I either lost you at hello? No.
not at all. No? Thank you very, very much. We appreciate it. So our next presenter is, I have NPAL Service. So I'll ask you to take your place and introduce yourself and share with the committee how you would like to be addressed.
Good afternoon, Madam Chair. Thank you for this opportunity. I am Paul Service. I am currently the Chief Director for Halifax Search and Rescue. I'm here today representing my 150 members out of a total of 300 GSAR volunteers within the Halifax Regional Municipality. Ground search and rescue teams play a vital role in our community, often operating under perilous conditions to save lives, provide aid, and ensure the safety of residents and visitors alike. GSAR volunteers have often been referred to as a duct tape of the emergency service response system, tirelessly dedicating themselves to serving others in times of crisis, stepping in to provide specialized skills and surge capabilities to emergency responders when our communities are facing adverse challenges. Over the last 2 years, our team has responded to what we call the 4 Fs: Fiona, fires, floods, and flurries, or the massive snowfall that besieged Nova Scotia earlier this year. During the recent snow event, our members supported our unhoused neighbors in intense snow conditions, and we responded to the municipality's first calls on their voluntary vulnerable person registry. aiding the municipality's most vulnerable residents who needed just a little bit of assistance during that snow event. I'd also like to take a second to recognize the mental health toll on many of our first responders and many first responders to these extreme weather events. They are high-stress events well outside the operational norms for our responders, and I know firsthand that search and recoveries during these events exact a toll on our responders. Adequate mental health support must continue to be part of this conversation. Through all of this, all of our calls on the emergency management front, we have maintained our core mission to aid the municipality's lost, missing, and injured persons. In the 2023 fiscal year, our team was active for 76 operational periods. 13 of those were for missing person searches in our primary coverage area. Nearly half of those were for people in mental health crisis. Another 25% of those were for individuals in some level of cognitive impairment. And then we responded 17 times outside of our coverage area for mutual aid, and 36 times, or 44% of our operational callouts, were for civil emergencies related to climate change. This is up from just one, perhaps every other year. This shift underscores search and rescue teams' growing importance to emergency managers. While we continue to do searches for missing persons with skill and professionalism, we are becoming less and less about missing people and more of an all-hazards response organization. It is important to note that disaster response is not a new space for volunteers. The German Technique Health Work and the Australian State Emergency Service are government-funded, highly trained, volunteer-based organizations that respond to civil disasters in their communities. The Elliott Lake Inquiry, when discussing the THW, noted that purchasing equipment and training volunteers to respond is far cheaper than maintaining a career force to do the same function. Volunteers also bring incredible pride and passion for serving their communities, as the Premier has already noted. While some paid emergency responders may look down on volunteer GSAR as an illegitimate footnote in their world, GSAR teams have become a force multiplier during disaster response. A trained, disciplined, multi-purpose team at the ready, we are a team that actively trains with natural resources, fire, police, and Coast Guard groups. We operate with a tried and tested command and control system that seamlessly integrates with EMO through years of training and experience in the nationally accepted incident command system. Our volunteers work with the RCMP to evacuate our communities during the recent wildfires. Our members staff roadblocks with the RCMP as fire operations continued, helping individuals out of the fire-affected areas. Our Marine crew, utilizing sonar, located a helicopter firefighting bucket in 30 feet of water that was dropped after a reported mechanical issue with the helicopter. That bucket was returned to the surface by our team members and subsequently to firefighting duty. A few months later, during the floods, our Marine crew again tested their swift water rescue capabilities by helping to rescue 30 people in Bedford. Like all of our members, I am also a volunteer. In my early 40s, I returned to university and studied communications. A few years later, I graduated with double minors in nonprofit leadership and public policy. During my university years, many of my professors became well-educated on the ground search and rescue system in Nova Scotia, as many of my papers focused on this area. One of my special interests was around the public policy surrounding ground search and rescue in the province. I'll go back and say at one point in time, the running joke in the ground search and rescue community was that EMO stood for the ex-Mountie organization. Many of the responders or many of the individuals at EMO were retired RCMP members. They knew GSAR volunteers, they understood what we did, and they understood the capability that they brought. They were involved with our day-to-day operations. Then something shifted, and they withdrew from this space. While this was a significant change, my research and public policy quickly answered this question. The only reference to emergency management in the Act is a statement on award recognition. The Halifax Charter and the Municipal Government Act both assign the responsibility for GSAR to the municipalities in the same way that they assign the responsibility for fire protection. Many of our volunteers have had a hard time adjusting to that fact after provincial EMO was so involved in our lives. While many are reluctant to, speaking of GSAR volunteers, while many are reluctant to admit it, members of different GSAR teams in the province have shared with me that the GSAR community is facing many of the same challenges as the fire service in the province. For many teams, shrinking and aging populations are making it harder to attract and retain volunteers. Limited policy and minimum support from EMO means it's challenging to focus on running a team on a day-to-day basis. What we perceived as a slap in the face with the announcement of the Guard legislation now presents as a significant and exciting opportunity for GSAR to modernize, coordinate, and advance our role in disaster response in the province. It has also provided a platform to discuss the policy surrounding GSAR, or lack thereof, highlighting the need for improvement. Notably, Clause 9 of the Act assigns responsibility for the volunteer fire and ground search and rescue services to the Minister of Emergency Management. This is a significant improvement for us, as it will allow us to communicate with the fire world on a regular basis. While ground search and rescue and volunteer firefighters may coordinate well as boots on the ground, it is noteworthy that falling under the same department may allow enhanced capability, awareness, and sharing, benefiting the lost, missing, or injured person in the province. The Guard provides an opportunity to develop a world-class disaster response system, and we look forward to being part of it. Thank you.
Thank you very much, Paul Service. Are there any? Oh, I'll recognize Gary Burrell. Thank you very much.
Thank you. I just want to make sure we get clearly, it sounds as though you're saying that your view of the proposal of the Guard has changed. Did I understand that right? That originally you had some pretty major concerns about how it was reflecting on ground search and rescue, and that these are no longer the case? Is that what you're saying?
Absolutely. So I will recognize Paul Service.
Right.
That turns your microphone on.
Okay. Absolutely. Initially, when the announcement was made, we collectively as a group, we stood around wondering what we did wrong. We had been through 4 of the big environmental issues in the municipality in the last 2 years. This announcement was made, and we stood there wondering, kind of what happened. Why is the Guard coming in and replacing what we're doing? Is it replacing what we're doing? And then through communication with EMO and with the interest groups that they've been holding, we came to realize that it's gone from something that we were almost afraid of to something that we're actively welcoming, because we recognize the importance of coordinating before the disaster. There's multiple times that we've gone to, and even over the last 2 years, where we've been involved with disaster response. We walked away with lessons learned, and then at the next incident, we went back to the same learning curve. So this coordination of the Guard is critical to moving forward.
Thank you very much. I'll recognize Rafferty Costanzo.
Thank you. So if I understand it correctly, were you consulted about this bill or were you not? And also in regards to volunteers, are you hoping to join this, the provincial Guard group? Is that what I understand from what you said?
So I'll recognize Paul Service.
So we found out about the Guard when a reporter called me and asked me for my opinion on it after it was announced in the legislature. I mean, it's not to be, we normally would not have been consulted on something like that. So to answer your question, to that point, no, it was a complete surprise, no consult. But the consult that's come after has been incredible, frankly.
Thank you very much. And I'll go back. Is there any other? I'll go to John M. McDonald next.
Thank you, Madam Chair. So, so how many of the consults did you go to, and how did you find out about them?
So I'll recognize Paul Service.
So we've had a number of calls and contacts with the committee. There was one that was hosted in Beaverbank, which was attended. Frankly, it was open to the fire and GSAR community. The GSAR community showed up in numbers, and the heavy urban search and rescue team was also there. Fire was done at that particular event.
So, sorry, I recognize Rafferty Costanzo.
No, I'm fine. I guess the legislation was introduced in the spring, and since the legislation, you've been having a lot of consultation, correct?
Exactly.
Thank you. And in regards to volunteers, are you concerned about losing your volunteers, or you're just going to join the new group?
So I'll recognize Paul Service.
So my understanding from the working group is that we will be, emergency management will be coordinating the overarching piece. Our volunteers will remain our volunteers. Guard volunteers will operate at different tiers than what we have, and from what I understand, the first tier is equivalent to what we already have in the municipality, which is a GEMS council, so opening warming centers and that type of thing. We're very familiar with that. We've supported them in the past during disaster. And then the second tier will be somebody that has a quantifiable skill. So if you have a chainsaw operation, you can come and demonstrate it, and then when there's a need for chainsaw operators, we can draw down from that list to back up what we're doing. And then GSAR will operate at the top, essentially the top tier. And we still will remain as our independent groups at this point in time. So I have no fear. I think some of our members may be looking as an enhanced way to serve their community, but I have no fear of losing my members. So.
Thank you very much. I'll go to Braden Clark next.
Thank you, Madam Chair. I'm certainly no emergency response expert. This is coming from kind of a layperson's perspective, but something that always strikes me when we talk about these incidents after the fact, and you touched on this, Mr. Service, is coordination and how critically important that is. That's kind of the thing that keeps it all together, obviously. So, from your view, this bill 455, whether it's the Guard, but also more particularly, I guess, the establishment of the department and so on, how do you see that as it relates to coordination going forward? Do you see that overall as a positive step, or where do you see that piece of the puzzle as it relates to this bill?
Thank you. Sorry, I recognize Paul Service.
It's absolutely critical to our mission, frankly. The coordination piece that they're going to bring, what we can do, the conversations that we're going to have, or that we can have. Frankly, we lack that now. We don't have the ability to. We may communicate with the province when there's a larger event going on, or when we have an issue to our day-to-day operation that rises above where our normal scope of operational management is. But this whole communication piece, this whole coordination piece, pre-planning before we get to an incident, knowing that my team has swift water rescue capabilities and are highly experienced in it, that we're not discovering in the morning of a flood that we have this capability, and we're not responding to outside of our community with this capability. So this is what is coming with the Guard is this coordination piece is beyond critical for our conversations. We can't continue to discover capabilities in a disaster.
Thank you very much. With 1 minute left, I'll go to Steve Craig.
Thank you, Madam Chair. Mr. Service, good to see you again. The last time we saw each other was at that August 2nd meeting out in Beaver Bank. And as I recall, you had a lot of questions then, and as did other people there, but you found, I'm hearing now, I didn't follow up with you, but I'm hearing now that you found that useful, and also the contacts that you made in getting answers to what might be and how to shape the future. Is that a fair characterization of my view of what you're telling us now? Is that a good thing?
I recognize Paul Service.
That's very fair. It is a good thing. It, again, we had that arc of discovery, from a reporter to, where did we go wrong, to, wait a second now, these are issues that we've been having that we haven't been at the table, frankly. Again, I talked about the illegitimate stepchild of the emergency service world. Now we're going to the table. Now we've been asked for our opinion. And so this is really important, and this has been fantastic, frankly.
Thank you very much. That's the time for now. So we thank you very much for coming in to present. Appreciate it. So we are now going to go back to Bill number 464, the Stronger Workplaces for Nova Scotia Act. Oh. Well, this is good news. We're going to take a break, short break for now, while we wait for our next presenters. We're a little ahead of schedule, so we'll...
Break share.
There you go. All right, we'll be back shortly. We're in recess. Thank you very much, everyone, and welcome back to Law Amendments Committee. My name is Barbara Adams, and we're going to continue on our programming today with Bill number 464, Stronger Workplaces for Nova Scotia Act. And our first presenter of this afternoon session is Nan McFadgen, and we'll welcome her to come take a seat to introduce herself and to share with the committee how she would like to be addressed during questions.
Hi, my name is Nan McFadgen, and you can call me Nan. I'm the president of QB Nova Scotia.
Thank you very much.
You're welcome.
And you can begin your presentation whenever you're ready.
Does that mean I get like an extra half hour because you're running ahead and I'm early?
Well, if we hadn't taken a break, Nan, I'd have been happy to do that, but unfortunately, we took a break.
I'm just messing with you. So in I could wait. In Nova Scotia, the Canadian Union of Public Employees represents over 22,000 members working in healthcare, social services, municipalities, P-12 education, P-12 education, post-secondary childcare, and that doesn't even name all of our sectors. That's the short list. Earlier this year, CUPE participated in the community partner consultation on proposed amendments to the Labor Standards Code. With respect to the unpaid serious illness or injury leave and unpaid sick leave, we attended a consultation session and also made an additional written submission. This is to say, we care deeply about Bill 464, Stronger Workplaces in Nova Scotia for Nova Scotia Act, and respectfully provide the following submissions to the Law Amendments Committee. We have also provided a written submission. So, still no paid sick days. CUPE is disappointed to see the government of Nova Scotia's continued failure to institute paid sick days in the province. Currently, federal employees, as well as workers in several Canadian provinces, have access to paid sick leave of up to 10 days. In this respect, Canada is lagging behind most OECD countries, the majority of which have national, permanent, paid sick leave laws. No number of unpaid sick days is meaningful if workers cannot afford to take them. The expansion of unpaid sick leave only benefits the few workers who can afford to stay at home when sick, or who cannot afford it but have no choice but to stay home. And it seems as though this government is committed to making life more difficult for the majority of workers in the province. A day after Bill 464, the Conservative government introduced Bill 467 to make life harder for renters. Based on the latest CCPA report, the living wage in Nova Scotia is $26.53, while the minimum wage lags shamefully behind at $15.12. How are workers supposed to take unpaid sick days when they can barely keep a roof over their head? The continuous refusal to institute paid sick leave prioritizes immediate profits over longevity of workers and businesses. When there are paid sick days, workers can take their time to heal and rehabilitate, which in turn also helps businesses in the end. We ask that Bill 464 be amended to include 10 paid sick days. We welcome expanding the unpaid serious illness or injury leave to mirror the expansion of EI sickness benefits. That is precisely why the qualification process and guiding principles behind expanding the leave should be as low a barrier as possible, with qualifications and conditions not different than those used for the EI application. Navigating the EI system is challenging enough. If the leave is to have different qualifying requirements and conditions than EI, then accessing the leave and EI is compromised. Such barriers are stronger vis-a-vis newcomers and those with lower literacy and lower technological skills. Bill 464 has not defined serious illness, leaving it to the whim of future regulation. It is critical that a legislation aimed at expanding leave for serious illness and injury actually define serious illness and injury to provide clarity for both workers and employers. We ask the definition of serious illness under Bill 464 should be amended to mirror the definition of same under the Employment Insurance Act and its regulations. That is, any illness, injury, or quarantine that renders a claimant incapable of performing their duties on the regular or usual employment or of other suitable employment. Determining whether this threshold has been met is up to one's healthcare practitioner. As it stands, Bill 464 imposes a minimum employment tenure of 3 months prior to qualifying for the leave. Nova Scotia does not have paid sick leave. Therefore, it is unconscionable to impose a minimum tenure requirement for qualifying for extended unpaid sick leave. Serious illness or injury do not time themselves with how long you've been working for one or another employer. You can get sick at any time. Have we not learned anything from the pandemic? And most workers in Nova Scotia are only a few paychecks away from losing their homes and going hungry, which is a policy decision of this government. Workers without just cause protection, primarily non-unionized, can lose their job as long as notice provisions of the Labor Standards Code are met. The serious illness or injury leave is a measure to provide workers with a minimum level of job security, even though employers still have the power to terminate employment. To then further limit this scant level of job security due to one's short tenure would undermine the very purpose for which the leave is instituted. Let's not forget that qualifying for EI is already an onerous process and has many requirements for length of employment, such as the requirement to have worked at least 600 insurable hours in the previous 52 weeks. That is why qualifying for serious illness and injury leave should be as low a barrier as possible, because if you can't get this leave, you are unlikely to apply for EI. This leave is the gatekeeper of access to EI. There is no principled reason to effectively deny access to EI to a worker who falls ill on the second month on the job, other than outdated ableist views of worthy and productive workers. We should not lose sight of the fact that we are talking about unpaid leave. By definition, the employer is not spending a dime on workers taking such leave. In fact, EI is funded by contributions from the workers themselves. Any inconvenience or minimal cost posed to employers as a result of unpaid leave is justified to avoid the above-mentioned concerns. Bill 464 does not outline the required medical information to support the leave, only that regulations, yet again, will be made in the future. And in the absence of regulations, information will be requested that is reasonable in the circumstances. What does that even mean? In practice, in the absence of clear guidance, reasonable in the circumstances gives significant power to employers in determining the form and content of supporting medical information. Well, workers already need to get a medical certificate for their EI claim. By default, the medical certificate should be accepted by employers for accessing this leave. There is no reason to burden the healthcare system twice for the same illness or injury. Also remember that the Patient Access to Care Act reduced unnecessary burden on the healthcare system. That should apply to this serious illness and injury leave as well. So notwithstanding the default approach to accept the EI medical certificate, the expanded range of healthcare professionals who can provide a certificate about a worker's illness for accessing sick days in the Patient Access to Care Act should apply to this leave as well. We also submit that employers should be bound by a timeline for requesting a medical note. There is a timeline for the employer to request a note in the federal sector in the Canada Labour Code. Employers have 15 days to request a medical note after a worker's return to work, and employees have to provide the note only if it is reasonably practicable. If workers are expected to inform the employer as soon as possible about their intent to take leave, then it's only fair that employers have some level of restriction on their ability to request that note. I want to thank the government for this opportunity to make these comments on the proposed changes to the unpaid sick leave and unpaid serious illness or injury leave, and hope to see the above-mentioned amendments to the bill 464. Thanks.
Thank you very much. I recognize Gary Burrell.
Thank you. Well, thank you for this detailed explanation. And we had spoken earlier today with other presenters about the importance of paid sick leave as this being part of this conversation, that it doesn't really make sense to offer the protections that we're looking to offer unless paid sick leave is part of the equation. I wonder if you could speak any further to that about just the importance of extending paid sick leave as a way to accomplishing the very objects that are in this bill.
Thank you. I recognize Nia McFadden.
So I think it's really just a no-brainer. It's a political no-brainer. It's a moral no-brainer. It's a humanity no-brainer. That if I were to get cancer tomorrow and I made let's be generous and make it $16 an hour, am I taking time off to look after that cancer? What I'm doing is I'm working as long as I can, and I'll look after it at the latest possible moment. And then when you do the math of that, nurse by trade, then the healthcare system suffers because I've put it off because I'm not well, but I don't have enough money to be sick. And if you were to say to me, but you've got this unpaid sick leave and you can go make, I don't know what you make on sick leave, like half of $16 is $8. So I don't know anybody who can buy that loaf of bread that everybody talks about, or put gas in your tank at like $1.50 a liter with $8 an hour. And you still need the bread and you still need the gas when you have cancer because you have to go to treatments. I just don't understand why everybody in this room, and I include myself, who are people of privilege in this province, could not see their way clear to provide those who struggle with paid sick leave. It's such a basic humanitarian thing to do. It's just so basic, and we can't do that. I don't understand it.
Thank you. Are there any other questions? No? Well, thank you very much for being here today. We appreciate your time.
No worries. I'll come early next time, too.
Okay, so we're going to revert back now again to Bill number 455, the Emergency Management, an Act to establish a Department of and authorize the establishment of a Nova Scotia Guard. Our next presenter is Ansel Langell. I'll ask you to come to the podium and have a seat. And if you would, introduce yourself to the committee and share with us how you would like to be addressed during questioning.
Good afternoon. My name is Ansel Langell. I am the Senior Manager for Emergency Management with the Canadian Red Cross, and you may refer to me as Ansel.
Thank you very much. The floor is yours.
Thank you for allowing me the opportunity to speak today. I am pleased to be here to speak on behalf of Bill 455, specifically to the creation of the Nova Scotia Guard. The Canadian Red Cross is committed to our own organization's growth and response capacity and its preparedness activities here in Nova Scotia and across Canada. The Canadian Red Cross is extremely proud of our long history in Nova Scotia of disaster response and have supported and responded to many significant natural and man-made disasters. And our capacity and official relationship with the Government of Nova Scotia in emergency management began in September of 1998 with the crash of Swissair 111. Since then, we've responded to many emergencies and disasters, including but not limited to floods, hurricanes, forest fires, neighborhood lockdowns, and the tragic mass shooting in northern Nova Scotia. We are well integrated within the emergency management community in this province and work with several partners and stakeholders, including governments, nonprofits, and the corporate community. During large-scale and sometimes even medium-scale disaster events, such as the hurricanes and fires and floods that we've experienced in this province, we have appreciated and experienced the desire of residents and the community to assist those that have been impacted by a disaster. And when I say assist, is to contribute to their volunteer time and talents. The creation of the Nova Scotia Guard recognizes the desire by many Nova Scotians to contribute in times of emergency, and the Nova Scotia Guard will allow for a coordinated approach to deploying people when and where they are needed most. Once fully implemented, the Nova Scotia Guard will engage Nova Scotians with a broad range of skills and interests who are possibly not affiliated with another organization, and in fact will be able to respond to emergencies in their own community and across the province. The Canadian Red Cross, a long-standing humanitarian and volunteer service agency, welcomes the opportunity to support this critical work and share our expertise and insights gained across hundreds of responses here in this province and across the country. Thank you.
Thank you very much. Do we have any questions? Well, I'm on a roll here. Thank you very much. We appreciate your time in coming here today.
Thank you.
Our next presenter is Chad Schrader, and I'll ask Chad to come to the podium and have a seat and to introduce yourself and to share with the committee how you would like to be acknowledged.
Thank you, Madam Chair. My name's Chad Schrader. I'm the Deputy Fire Chief, Wolfville Fire, Kings County, and you can refer to me as Chad.
Thank you. The floor is yours.
Good afternoon, honorable members. Today I sit before you not just as the Deputy Chief of the Wolfville Volunteer Fire Department, but as someone who has lived through the profound impacts of the recent disasters that are affecting our communities. The tragic floods in Wolfville and West Hants and the intense wildfires in Shelburne County have underscored the urgent need for a more effective and coordinated approach in emergency management in this province. Over the past year, our experience during these crises have highlighted three critical areas for improvement. They are coordination, communication, and volunteer management. In each of these events, from the floodwaters that ravaged our towns to the wildfires that endangered our communities, it became abundantly clear that we need a more streamlined and integrated approach to handling emergencies. The feedback we have received from these events, as well as others, would be supported immensely by the legislation we are discussing here today, Bill 455. It represents a pivotal step forward in our collaborative efforts to safeguarding Nova Scotians during times of crisis. From the creation of the creation of the new Department of Emergency Management is a significant advancement. It's going to give us the ability to unify our essential services such as the Emergency Management Office, Business Continuity, 911, and the Public Safety and Field Communications Department. That's a tongue twister. It's going to ensure all of these resources are under one roof. From my firsthand experience with the recent floods and wildfires, I can attest to the critical need for a cohesive and well-organized response structure. This integration will enhance our abilities to support our responses swiftly and effectively. Additionally, the establishment of the Nova Scotia Guard is a game changer. Having witnessed the extraordinary efforts of community volunteers during these recent disasters, I can attest to their invaluable contributions. The Nova Scotia Guard will enable this province to mobilize a diverse group of volunteers and community organizations with a wide range of skills. Whether it's delivering essential supplies, operating heavy equipment, or transporting animals, the Guard will help ensure that we have the resources that we need when we need them, with efficiency and precision. It will also help alleviate so many of the pressures that we face on the ground in these very, very overwhelming events. I envision the Guard having the ability to work closely with our various partners. This includes businesses that provide critical services, non-government organizations, the dedicated volunteer responders like our firefighters and ground search and rescue teams. This collaborative network could bolster our capacity to handle emergencies and will support our communities more effectively. Furthermore, Bill 455 includes an important measure to improve our communication and coordination with our municipalities. It is important to the volunteer fire service that we work with a more standardized approach, whether it's the alerting system, fire dispatch, regional emergency management, or the vulnerable persons registry. All of these aspects help us respond more efficiently and effectively on the ground during these types of events. This proactive approach will ensure that our communities are well prepared and can act decisively in the face of future emergencies. In closing, I want to emphasize that this legislation is not just a set of policies. It's a testament to our commitment to learning from past events and enhancing our emergency response capabilities. Bill 455 embodies the forward-thinking approach that will help our firefighters better manage crises and protect the people of Nova Scotia. In closing, I'd like to thank you all for your attention and your dedication to improving the safety and resilience of our beloved province. Thank you.
Thank you very much. I recognize Rafa Costanzo.
Thank you, Madam Chair. This is a question we had for the first person who was here from Halifax Professional Firefighters Association, and he was disappointed, upset that they were not consulted. Were you consulted? And my same question I asked others is about the volunteers. Are your volunteers going to be the same volunteers as the Guard? And how does that work?
So I recognize Chad Schrader.
Thank you, through you, Madam Speaker. We were consulted, so the volunteers through firefighting and ground search and rescues did have the ability to attend many in-person or virtual events over the course of the last few months. I attended one of those events myself personally in the Kempful Fire Station. We had presenters from the DNR folks. Minister Lohr was there as well, and a couple other MLAs for the area were there. It was more designed to really understand what the Guard was and what it could do to help us. So yes, in short, we were consulted. To the second point of your question, it will not take away from our volunteer base. The Guard is really designed for those folks that do not have the time to dedicate their time to a volunteer firefighter or ground search and rescue team. It's a very demanding time. It's a commitment, a significant commitment. We train weekly, we have meetings, we have events. Our fire service is almost hitting the 250 calls for this year, which is significantly higher than it has been. So not everyone wants to commit that time, and we have to have a commitment. It costs a lot of people to equip, train these folks to be ready for a frontline event. So this opportunity gives Nova Scotians who otherwise want to make sandwiches, who have skills that they don't know how to harness and deliver to people in need. It gives them an avenue that's managed. Volunteer management is a huge thing. It gives them the opportunity, the avenue, if they would like to help Nova Scotians. This is it.
Thank you very much. Are there any other questions? Well, thank you very much for being here. We appreciate your time. We'll now call upon Colin May. Is Michael Lockett here? Well, we are well ahead of schedule. I don't believe, are there any other presenters who are here prepared to go? I guess we're going to take a recess until we have another presenter. Thank you very much. We are in recess. Order. I'll welcome everyone back to Law Amendments Committee, and we are discussing Bill number 455. Thank you very much. So we are here to do Bill number 455, the Emergency Management and Act to establish a Department of and authorize the establishment of a Nova Scotia Guard. We have new MLAs here, so I'm going to go around the room and ask everyone to introduce themselves, starting with the government side.
Good afternoon. Dave Ritzy, MLA for Truro, Bobble Hill, Millbrook, Salmon River.
Hi, everyone. Marco McLeod, MLA Pictou West.
Pat Dunn, MLA, Pictou Center.
Good afternoon. Steve Craig, MLA for Sackville-Cobequid.
Hi, Lisa Lachance, MLA, Halifax, Sable Island.
Rafa Di Costanzo, MLA for Clayton Park West, and I will be replaced shortly by Ben Jessam, MLA Ben Jessam.
Fred Tilley, MLA, Northside Westmount.
Thank you very much, and I'll ask Colin to begin his remarks.
name's Colin May. I'm a 50-year resident of Metro, with no regrets, I'll say. Former member of the Dartmouth City Council, former member of the Dartmouth Board of Police Commissioners. I'd have to say that I've read the Police Act in every province, so I'm quite au fait with how they govern policing. And the difference in Nova Scotia is that you go across the major cities and major municipalities from Nova Scotia West, the police board is completely independent. The chief of police reports only to the police board and also to the Minister of Justice or the appropriate minister. He doesn't report to the mayor, doesn't report to a council. And for years I've said that the province should do the similar thing. Now, while I favour the bill, I just wanted to get into the fact that I wouldn't have known about this bill if I hadn't checked in on noon on Friday when HRM puts their next week's agendas up. And on there, for the council meeting, is a memo dated August the 21st where the CEO is recommending amendments to bylaw P100, which governs policing in Halifax. Now, in her memo, she claims that there was extensive consultation with officials in the Department of Justice. So if I can turn, I'm mainly interested here in the role of a police chief in the case of an emergency. I'm a strong believer of the independence of policing. And as the son of a police inspector, you can imagine what it's like being a child when you have a parent in the police service. You're expected to be completely well-behaved and not get into trouble. But I'd have to admit that that wasn't my case. As one officer said to me, "I know who your father is." In this proposed amendment to the bylaw, the CEO believes that Section 38 of the Police Act, the Chief of Police has authority over the actual day-to-day direction of the Halifax Regional Police with respect to enforcement of law and the maintenance of discipline within the department. She recommends that be repealed. Then further after that, the Chief of Police is accountable to the Commissioner with respect to the fulfillment of the Chief of Police's responsibility for the actual day-to-day direction of the Halifax Regional Police with respect to the enforcement of law and the maintenance of discipline within the Halifax Regional Police. That's completely counter to the Police Act. Why that would be? It's actually a power play. You know, I've been going to Halifax Police Commission meetings since 2010. I've seen provincial appointees who never showed up, including the most recent one who departed a couple of months ago. Barely showed up. When he did show up, all he did was say aye in a vote. Contributed nothing, which was disappointing. A previous one was the former number 2 RCMP officer of Canada, who'd been in charge of the RCMP officers from the Manitoba border east. So he was appointed. I can't remember which government appointed. He was appointed. He started missing meetings, phoning it in. I asked somebody on the board, you know, when he phoned that in, where was he? And he says, "Oh, I think he's got a summer place down south in the States." So I wrote to the then Minister of Justice outlining the dates that this person had never attended the board meetings and suggested that the minister should consider replacing him. all I got back was, oh, well, that's up to the city. Anyway, the other section I wanted to come to was that powers that are presently residing within the police chief are proposed to be transferred to the Commissioner of Safety that works for the city. Now, I don't know, where's that happened anywhere else in Canada? I mean, the present chief was acting chief for almost 11 months. And only recently was he fully appointed as chief. And he has a contract which we'll never see, perhaps somewhere in there. I'd suggest that this, whoever it was in the minister's department who dealt with the city, should brief the minister on the proposed changes and maybe have a discussion about how such changes would significantly reduce the role of a police chief compared with police chiefs throughout the country. And I just finish by saying, the sooner we have legislation that makes police chiefs solely responsible for policing, the better. And I can remember Bill Blair during the 2020 G7 meeting in Toronto, and they corralled a lot of demonstrators. And at a press conference, Chief Blair was asked, what did the mayor think of what you did? And Bill Blair said, quite rightly, I don't report to the mayor. I report to the police board. Unfortunately, a chief in Halifax can't say that. And I'll just finish with one last thing. If you look at the bylaw for the police in Bridgewater on the website the other day, it referred to the Police Act of 1974. We really need change in the governance of policing. And I don't think this deal that's being hammered out between the minister's department and senior staff at HRM is in the best interests of policing. In fact, it's, as I said, it's contrary to the Police Act. That's all I would say. Thank you.
Thank you very much. Are there any questions? No? Thank you very much. We're going to take a short recess. Good afternoon, order. My name is Barbara Adams. We're going to resume Law Amendments Committee, and we are talking about Bill number 455, the Emergency Management, an act to establish a department of and authorize the establishment of a Nova Scotia Guard. And our next presenter is Michael Lockett. I'll ask you to introduce yourself and to share with the committee how you would like to be referred to.
Good afternoon. My name is Mike Lockett. I'm a director of the Canadian Volunteer Fire Services Association, and Mike is perfectly fine.
Thank you very much. The floor is yours.
Thank you very much. Thank you for the opportunity to come and speak on behalf of the amendments to the bill. Like I said, my name is Mike Lockett. I am a director of the Canadian Volunteer Fire Service Association. I just got back from our National Memorial in Ottawa, so I apologize for not having this on paper. I will be reading this off my tablet. So, it is with great respect and a sense of national importance that I address you today regarding the groundbreaking advancements introduced through Bill 455. Our association, which represents not only the dedicated volunteer services of Nova Scotia, but also nationally and right across the entire country, is keenly aware of the profound impact this legislation will have. The evolving nature of emergencies across regions has highlighted the need for comprehensive approaches to emergency management and fire dispatch. Effective regional emergency management requires not only a robust framework for response, but also seamless coordination of fire services. The ability to integrate these elements ensure that communities are better prepared, response times are minimized, and resources are allocated effectively. Bill 455 introduces crucial advancements in this regard, setting a precedent for how we can enhance our regional approaches to managing resources and dispatching of our services. Bill 455 introduces key advancements that are transformative for Nova Scotia and serve as a model for emergency management practices nationwide. Improvements in the regional approach to emergency management and dispatching services are particularly noteworthy. Effective and efficient coordination is the backbone of a successful emergency response and will significantly benefit volunteer fire services in Nova Scotia. Enhancements would streamline communication, reduce response times, and ensure that resources are deployed where they are needed the most. For our volunteer firefighters, this means clear directives and better support, enhancing their capacity to respond to emergencies swiftly and effectively. A standout feature of Bill 455 is the establishment of the Nova Scotia Guard. This initiative is particularly relevant as it addresses a growing need across Canada for systemic coordination of volunteers. The Nova Scotia Guard represents a forward-thinking approach to mobilizing and managing volunteers, citizens, non-government agencies, and businesses during emergencies. By creating a structured network that includes a broad range of skills and resources, the Guard ensures that everyone who wishes to contribute can do so in a coordinated and effective manner. That is the key statement, a coordinated and effective manner. In recent crises, we have seen the individual contributions of volunteers and community organizations. However, without a systemic approach, these efforts can sometimes lack coordination and efficiency. The Nova Scotia Guard will provide a framework that allows for better integration of volunteer businesses and non-governmental organizations into the emergency response process. This model will enable a more organized and effective mobilization of resources, ensuring that each participant's efforts are maximized and the support is delivered where it's needed most. This approach is essential as we face increasingly complex, frequent emergencies across Canada. By adopting a systemic method for coordinating volunteers and leveraging the expertise of various community sectors, we can enhance our overall response capabilities and build more resilient communities. Additionally, Bill 455 emphasizes an enhanced communication with municipalities. It's crucial for effective emergency responses. The advanced notice of changes to the alerting system, fire dispatch, and regional emergency management organizations will provide our volunteer fire services with the necessary information and tools to stay prepared and respond effectively. This proactive measure will improve readiness and ensure that our communities receive timely and coordinated support during crisis. In conclusion, the improvements introduced in Bill 455 are a testament to the commitment in advancing emergency management and supporting volunteer fire services. These changes represent a significant advancement not only for Nova Scotia, but also as a model for emergency management practices right across this country. They reflect our collective dedication to enhancing the safety and resilience of communities nationwide. I thank you very much for this time and the unwavering support for these vital initiatives.
Thank you very much. Appreciate that. Are there any questions from the committee members? No? Thank you very much. We appreciate your time and for coming.
Thank you very much.
You're welcome.
Have a great day. The weather in Nova Scotia is much better than it was in Ottawa.
All right, now we're going to go back to Bill number 464, the Stronger Workplaces for Nova Scotia Act. And our next presenter is Sandra Mullen, and I'll ask Sandra to take her place and to introduce herself and to share with the committee how she would like to be addressed during questioning. Thank you. Go ahead, Sandra.
Good afternoon. I'm Sandra Mullen, and I'm president of the Nova Scotia Government and General Employees Union, and you can call me Sandra.
Thank you. The floor is yours.
Thank you. I represent over 37,000 public and private sector workers who deliver programs and services that Nova Scotians depend on every day. I, along with the other members of the labor movement, are here to speak on Bill 464, the Stronger Workplace for Nova Scotians Act. I won't repeat all the amendments that have been presented by the Federation of Labor, but I do want it noted that, for the record, the NSGEU agrees with all the proposed amendments outlined here previously. The union would like to recognize that this government legislation is a positive step forward in worker rights and workplace health and safety. However, there are opportunities to make the bill even better and help build a stronger, healthier, and more worker-friendly province. I will quickly highlight some of the key changes that should be made to the bill. These include giving all workers at least 10 paid sick days per year. Unpaid sick leave is a disincentive for people to stay home while ill and creates more financial stress and disadvantage during the time when many families are already living through an affordability crisis. The entitlement of 27 weeks is an improvement. However, the unpaid nature of these leaves is concerning for the same reason as previously mentioned. The need for clear regulations related to proof of personal illness. This is a private health information, so determining what is reasonable for the employer and the employee must be clear. There is no current definition of what is considered reasonable, and that must be addressed. The NSGEU is here today to strongly advocate for some specific changes. Under the Occupational Health and Safety Act, Section 13, subsection 4, is currently read, every employer shall, in accordance with the regulation, establish and implement a policy respecting the prevention of harassment in the workplace. The union would advocate to include harassment and bullying. Also, in line 18, starting at subsection 82(1) of Chapter 7, the clause JA reads, respecting workplace harassment. The union would advocate again to include harassment and bullying. This is an important distinction that requires an amendment. Bullying means behavior that targets someone for personal attributes. Bullying in the workplace is more common than harassment, and the Act needs to have it included. Many other provinces have bullying included in their legislation. For example, in British Columbia, employers are legally required to establish a clear anti-bullying policy and conduct regular training. Workplace bullying in Alberta is considered a severe infraction under the Occupational Health and Safety Act. And the Alberta Human Rights Act also prohibits harassment and bullying at work based on protected grounds. In Ontario, the Occupational Health and Safety Act sets out specific obligations for provincially related employers to prevent, investigate, and address workplace bullying and harassment. In PEI, harassment is defined in Clause 1B, includes both repeated inappropriate conduct, comments, displays, actions, or gestures gestures, or incidents of bullying that have an harmful effect on the worker's psychological or physical health or safety, and B, a single occurrence of inappropriate conduct, comment, display, action, or gesture, or bullying that has a harmful effect on the worker's psychological or physical health or safety. Continuing on in Bill 464, under the heading Workers' Compensation Act, line 21, Chapter 10, Section 89A, 1, subsection B, currently reads, attempting to provide suitable work that is available and where possible restores the worker's pre-injury earnings. The union advocates to add to these words suitable and meaningful. The same addition is required in Section 3, subsection B, which currently reads, assisting the employer as may be required or requested to identify suitable work that is available and, where possible, restores the worker's pre-injury earnings. The union would advocate for the words suitable and meaningful. Adding the meaningful is essential. The WCB Review Committee, during their public consultations, heard that some employees did have early return to work, but the work they'd returned to was not meaningful. In some instances, it was referred to as demeaning. The committee recommended that the work should be suitable and meaningful. And finally, turning your attention to line 23, section 161 of Chapter 10, of the Chapter 10 is repealed and the following section substituted. 161 subsection 4 reads, 4A, a review committee must consist of at least 3 members appointed by the minister. The union recommends amending the number of members to 5 and including the following. Appointed members shall consist of at least 1 injured worker, at least 1 worker representative, and at least 1 representative from a labor union. It is the position of our union that having only 3 members on a review committee is too small. The WCB is very complex, and the knowledge and experience provided from injured workers, and labor is important to ensure a fair result. In conclusion, the NSGEU commends the government for bringing the legislation forward. It is a positive step, and with some minor changes, this bill can go from good to great for the working people and their families. The NSGEU and its over 37,000 members stands in solidarity with all the amendments provided by the Federation of Labor, including the ones I highlighted this afternoon. Thank you for your time, and I'm available for questions.
Thank you very much, and I'll recognize Gary Burrell.
Thank you. I think we don't have written copies, do we? You do have them there? Okay, that's one, because some of what you said is very detailed. Yeah, great, thank you.
Thank you very much. Are there any other questions?
Yes.
Yes.
I want to go back to the point you made earlier.
Oh, excuse, I recognize Gary Burrell.
Thank you. I'd like to go back to the point you made earlier about paid sick leave. This is an issue that has been coming up over and over again as we've talked about these changes. I'm wondering, from the union's point of view, is the introduction of paid sick leave in this discussion an important change that you'd like to see?
I recognize Sandra Mullen.
You know, to encourage folks to take sick leave and put barriers in place of lost income is perhaps and most likely restricting those that can take time off without pay. So we have been lobbying for it. We certainly lobby for special sick leaves in all of our unionized workforce. But as you know, much of the work that unions do benefit those in non-unionized employment, and whether it's sick leaves, health and safety, it benefits all Nova Scotians.
Thank you very much. Are there any other questions? No. Thank you very much, Sandra, for coming today. We appreciate your time. We're going to take another recess. order. Thank you, everyone, and welcome back to Law Amendments Committee. Because we have changes in the representation by the MLAs, I'm going to ask for a round of introductions, starting with the government side.
Good afternoon. Dave Ritzy, MLA for Truro, Bible Hill, Millbrook, Salmon River.
Good afternoon, Marco McLeod, MLA Pictou West.
Good afternoon, John A. McDonald, MLA for Hants East.
Good afternoon, Brendan McGuire, MLA Halifax Atlantic.
Hi, I'm Lisa Lachance, MLA for Halifax Little Sable Island.
Gary Burrell, Halifax Shabukto.
I'm Ben Jessam, I represent Hammonds Plains, Lucasville.
Ellen Fred Tilley, Northside Westmount.
Thank you very much. And for those who are watching and wondering, we are going back and forth between two different bills. So we are now talking about Bill number 455, the Emergency Management, an act to establish a department of and authorize the establishment of a Nova Scotia Guard. I'll ask Lynn to introduce herself and to share with the committee how you would like to be addressed during questions.
Hi, my name is Lynn McCarran. I'm the Executive Director for United Way Cape Breton, and you can address me as Lynn.
Thank you very much, and thank you for traveling down today. The floor is yours.
Thank you. I'm really excited about this bill. The creation of the Nova Scotia Guard represents a proactive approach to enhancing our ability to respond to emergencies. This will ensure a more resilient and adaptive response to emergencies and natural disasters. Key benefits for me: increased coordination and efficiency. By centralizing efforts within a specialized department, the Nova Scotia Guard will streamline coordination and eliminate redundancies, leading to more efficient and effective operations. I experienced this firsthand with Hurricane Fiona, and when I was trying to take the lead working with the nonprofit sector. That was what I was assigned to do by the municipality. So I worked very closely with the Mennonites, who were doing all kinds of work in the area, tree removal, roof repair, that kind of thing. I was working with the nonprofit sector, but I didn't really know what anybody else was doing. So I was kind of in my little circle of network and doing my thing. As a result, the Mennonites showed up to do tree removal on a property that Rubicon had been assigned to do tree removal. So to me, that was inefficient, ineffective. We spent a couple of hours going back and forth trying to figure out who needs to go where, and then we went back to, okay, we need to have a coordinated list so that people aren't going to the same spot to do the same job at the same time. It's not very efficient, and it's not a really good use of resources. So I would have been really happy to have the Guard kind of to go to for that coordination piece and that understanding and that communication. I'm hoping to see a strengthened community engagement. The Nova Scotia Guard will work closely with local communities, fostering stronger partnerships and improving communication. This collaborative approach will enhance public trust and ensure that security measures are both effective and respectful of community needs. For example, one of the other things that I did was I was contacted by the municipality to say that they had comfort centers and that there was tea and coffee there. So I had a contact with the business owner. Most of the businesses were closed back then. Nobody had power, but he happened to have a generator. I asked him for 300 pizzas a day for the next 5 days. He was able to fulfill that requirement, but then we had to get the pizzas to the comfort centers. There was a shortage of gas. There was people concerned that if they volunteered to drive these pizzas out to these places, that they wouldn't be able to put gas in their cars. So there was a lot of coordination that needed to happen in order for a simple thing like getting pizzas delivered. My mom was sitting next to me. She goes, I can't believe how hard it is just to order pizza. So something that you would think would be quite easy. But it really had an impact on those community centers and the place where people could go. They could get a hot meal because you couldn't go to a restaurant to get a hot meal. They had no power at home, and they were able to charge their phones and communicate with people and let people know they were safe, and they were able to get a little bit of food in their bellies. So very, very important to me, again, if we have that coordination and that communication and people could have been notified that this is where it is, this is where you can go, and it would be I'm hoping, very streamlined. I hope this strategic move will address immediate concerns and prepare us for future challenges. So I want to build capacity and resiliency in these small little community centers so that we can be prepared for the next natural disaster, which we are sure is going to come, and that these community centers and volunteers have a place to go and that they feel respected, they feel vetted, and that where people who are vulnerable and in need of assistance feel safe and feel supported. And I think that's the goal of the Guard, and I think it's a really good opportunity for us to be able to support our communities, support our local volunteers, and make sure that in the next emergency that people are prepared and able to do what they need to do. That's all I really have. If anybody has any questions.
Thank you very much. Does anyone have any questions? Well, again, thank you very much for traveling all the way down here. We really appreciate you taking the time to do so.
Well, thank you for hearing me, because I do think this is really important. I'm very excited about it. So hopefully everything will go through as it needs to, and our communities will be happier and better prepared.
Great.
Thank
you very much.
Thank you.
So that is our last presenter on Bill number 455. So I'm going to ask for a motion. Oh. Okay. I will open the floor to Gary Burrell.
I move that the bill be returned to the department to provide for the consultation with Halifax Professional Firefighters Association, which has not yet taken place, and that the bill could then return to the legislative process after that consultation has happened.
Sorry, I recognize John M. McDonald.
Just the proper normally would be to close presentation before we do such a motion, if I'm not mistaken. But I'll defer to we've always done it so.
His motion's in order. No, his motion's in order.
Okay.
Thank you very much. So I'm going to call for a vote on the motion. All those in favor of the motion say aye. Aye. All those opposed say nay. Nay. Motion is defeated. Thank you very much. I'll recognize Dave Ritchie.
A motion that presentations on Bill 455, Emergency Management, and Act to establish a Department of and authorize the establishment of the Nova Scotia Guard now be concluded.
Thank you very much. All those in favor of the motion say aye. Aye. All those opposed? Motion carried. Thank you very much. And I recognize Dave Ritchie.
Thank you, Madam Chair. I move that Bill 455, Emergency Management, and Act to establish a Department of and authorize the establishment of the Nova Scotia Guard be reported back to the House without amendment.
Thank you very much. All those in favor of the motion say aye. Aye. All those opposed? Motion carried. Thank you very much. And we are going to now move back to Bill number 464, the Stronger Workplaces for Nova Scotia Act. And we are waiting for our presenters to arrive. So we are going to take a recess. Thank you very much. Order. Welcome back to Law Amendments. My name is Barbara Adams. We are now with our final two presenters, Bill number 464, Stronger Workplaces for Nova Scotia Act. I'm going to ask our next presenter, Mary Lloyd, to introduce herself and to share with the committee how she would like to be addressed.
Hello, my name is Mary Lloyd. I'm president and founder of Pictou County Injured Workers Association. You can address me as Mary or...
Thank you very much, Mary. The floor is yours.
Yes, I want to speak today on this bill. I'd like to divide it up into two. The Occupational Health and Safety Act, the provision there on harassment, we would ask that it be inclusive of WCB and the employer and the service providers, because the worst harassment that a worker receives is under the hands of the WCB. When a worker is injured, they are the best person at the workplace until you're injured, and then your life changes. So I think this section has to be inclusive of the workers' compensation and the treatment of workers who succumb to this harassment when they're injured on the job and how they're treated after the injury. On the second part, the Workers' Compensation Act, I would like to inform this committee that we feel this is very premature, given the fact that this report came without consensus. Myself and Peter Boyles, the two injured worker reps, have not agreed to this report. And so therefore there's no consensus, and to think that the first priority of this report is the return to work. Our priority is prevention. Prevent the injury. That'll reduce the cost. That'll reduce the harm inflicted on the worker. So the fact that this is the priority, throw workers back to work. Our position is, and always will be, that the accident be reported, that there be an investigation, and remedial action take place, and then on the say-so of the treating physicians or service provider, healthcare provider, that it's okay for that worker to return to work. But the emphasis is on quick return. It's not on safety. So the provisions in the legislation that exists now, the employer's obligations under 89 to 101 provide that there's penalties already in place. Section 84 is the one for workers which is utilized all the time. The worker is cut off. The worker is threatened. The worker is intimidated. We don't need any further. We agree return to work is important, and workers want to be back to work because they want to be receiving their benefits, but they can't be going back to work and further injured. And that's what's happening now. We know in the healthcare, everybody's short-staffed, so you're throwing the injured worker back into that, which causes further injuries or a worsening of their existing condition. A problem with the return to work is the forms that are used. All injured workers are claimed to be sprain strains. They're not. It's that form assessment that's utilized that does that. In the service provider, you go to, the employer sends you. They're not a medical person. They're sending you for your assessment, and it's done in a clinic setting which is hostile to the worker. I'm a healthcare provider. I don't know of any patients that come with handles, and I can hold into close to me. And that's how you're assessed in these clinics. Everything's done with a milk carton. They put weight in there and they push you to find out what level of function is left. It does nothing about what the condition is or the diagnosis. It does nothing about what the worker's real capabilities or function is. It does nothing about the diagnosis. Everybody's labeled sprain, strain, regardless if it's a concussion, it's PTSD, it's a broken bone, you're all a sprain, strain under this program. So we urge you, this bill is premature. It's upsetting to us that this is the focus of this review, that the first priority is returning a worker back. What this means is that the worker, the board, the government, and the employer have failed that worker in the first place, that they got injured, because the prevention is not there. We want the emphasis on prevention, true prevention, and that's why part of the reason we didn't consent to this review is that the emphasis is not where they're supposed to be. There's nothing in this new review that's going to change anything that's going to really affect the worker. It's the same status quo. So we would urge you that maybe this part of the bill, the occupational health and safety part, go ahead, but the workers' comp part maybe be held for further review because I think it's premature. I've also provided a written, because at first we were told we couldn't get into this law amendment, so I provided the written one. It's also been emailed to you, so I'm not going to go through it word by word, but it basically speaks to what I've said. So I would ask this committee maybe to take this back and say, are we premature here? And if there's any further questions, I think my submission addresses these issues. So,
thank you very much, Mary. I'll recognize Gary Burrell.
Thank you for, we have the presentation written too. It's in all its details. So you were saying about the, with the review and the non-unanimous character of the review, and that part of the reason, if I understood you right, was you didn't accept the emphasis on return to work at the expense of prevention. But what about the rest of the reason? I'm curious about the you know, your overall set of reasoning for not signing on to the review.
Accountability. Yep. Accountability was our number one priority.
Oh, sorry. I have to recognize Mary Lloyd. I recognize you first. Thank you.
I'm sorry. Yes. Accountability is the number one priority that the injured workers, and it's the two injured worker reps that didn't give consent. Accountability, or the lack of, is basically, and we wanted provisions made to Section 167 that if it's demonstrated the board acted in bad faith, that we would have a recourse. But right now, we have no recourses. There's no accountability. And as far as this piece of review, it's not going to change anything there. It's status quo. It's not addressing the big fundamental issues with the board, and it's certainly not addressing the benefits, because they put in provisions that only when the board can afford it. But 47 years, this Nova Scotia Workers' Compensation Board has had an unfunded liability. And yet, it's status quo. There's nothing in there pointing the finger at them that you've been doing the same thing and nothing changes. It's on the backs of workers by cutting and slashing benefits. And they're waiting for some miraculous year that we're going to have a good interest rate to reduce the unfunded liability. That's the only thing that's going to change here. But when the new legislation came in, we weren't in favor of it, but at least there was two provisions put in that place, 115 and 116, and it was stated clearly that this would never, ever happen again. At the time the new legislation came in 96, the unfunded liability was $267 million. It went as high as $695 million. There's provisions there that says there can't be a penny added to this, that the legislation is clear that this will never happen again. But they just compound it and keep adding to it and adding to it and adding to it at our expense. The injured worker is living in enforced poverty because of a workplace injury or illness, and that's got to stop. This review does nothing to address that. So that's why we didn't give a consensus.
Thank you very much. Are there any other questions? Thank you very much, Mary, for taking the time to be here. We appreciate it.
Thank you for hearing me.
And our last presenters, I believe here, Peter Boyles. Thank you very much. Please take your seat. Peter, if you wouldn't mind introducing yourself to the committee and just sharing with us how you'd like to be addressed during questions.
Yes, my name is Peter Boyles, and I am a counselor in the municipality of the County of Pictou, and also I work with injured workers. And Peter is fine.
Thank you very much.
No, it just, Mary seemed to sum it all up, but I just, what I don't understand about the whole thing is, you know, you're here looking at some of the review committee's recommendations and that, but something that was never signed off on. There's not one signature on that whole document, and so I can't understand why the minister would even accept a document that's not signed. I mean, there's just a, you know, I think it could have been a great thing for this province and for us. And I know that Premier Houston turned around and really, he wanted to see this, you know, something be done, and this is why it was all started. But it ended up just like from day one, it was done, as far as I'm concerned, wasn't followed the way it should have been. It should have been handled, and so here we are today. We have them, they're rushing through some stuff here that we still have questions on, and we still have concerns about. I guess that as Mary said, the accountability stuff like that is just it's just bothersome that this happened. And that, it was just seemed like the cards were stacked against the injured worker right through the whole thing. So I just wanted to come in and let you know that and explain that to you. And I can understand that you guys got to do what you got to do, but we really think that this could have been a great thing if there just had been a little better leadership. Thank you.
Thank you very much, Peter. Are there any questions? I recognize Gary Burrell.
I understand, right? You have been a member of the committee behind the review.
I was a member of the review committee.
Sorry. I recognize Peter Boyles.
Oh, yes, I was a member of the review committee, sir.
Thank you. I recognize Gary Burrell.
So when you took the decision not to be a part of the majority report and to not sign off on the report, can you just explain to us some a little more about what your thinking was? What were your main areas of disappointment?
The big thing was...
I recognize Peter Boyles.
Sorry. Yeah, the big thing was from the start when the Premier said he was going to get this going and do something with it. He told us that Brenda Wilson at the panel, the Honourable Pat Dunn's office, would be the woman to talk to, and she would be able to lead us where we're going. But she was just left open backfield, and we couldn't get, the poor lady was not told anything. But we turned around and, again, I guess, sir, I went into a thing. What was your question again? I'm sorry.
So I recognize Gary Burrell.
I was just wondering if you would explain a little more about your thinking in why you decided not to sign off on the review.
I recognize Peter Boyles.
Well, nobody signed off on it. That's my thing, is who signed off on it? There's not a signature on it. And this is really bothersome. We were all told that we were going to come down here to a presentation of our work to the minister, and then at that time we figured we could explain to the minister if we had any problems or why we didn't want to sign or whatever. But instead, everything was stopped. Down came the chairman all by himself and presented, and that was it. And that was wrong. I mean, we turned around and we were put on this committee, asked to sit in this committee to do what we wanted to do, the right thing, to help injured workers, to help employers, to help everybody, to try and make it a better system, a system we all could be proud of. But we were sort of shortchanged as far as the injured worker goes. I'm sorry, but I have to tell you that. Yep.
Thank you very much. Are there any other questions? Thank you very much, Peter, for taking the time to come down here. We appreciate it.
Thank you guys very much.
Thank you. That's all of the presenters that we have today. So I am going to ask for a motion.
Yes.
So I'm going to recognize Dave Ritzie.
Hey, so motion presentations on Bill 464, Stronger Workplaces for Nova Scotia Act, be concluded.
Thank you very much. All those in favor of the motion say aye. Aye. All those opposed? Motion carried. I recognize Dave Ritzie.
Thank you, Madam Chair. I move that Bill 464, Stronger Workplaces for Nova Scotia Act, be reported back to the House without amendment.
Thank you very much. All those in favor of the motion say aye. Aye. All those opposed? Motion carried. Thank you very much, everyone. This law amendment session is concluded. We are dismissed. We are adjourned.